Good morning, everybody. We'll get started here right at 9 as people are still joining us. Welcome to our very popular yearly legal and ethical updates with Paul Cooney. Before we get started, we'd like to go over a few housekeeping items. Our presentation today is being recorded. As such, we ask that you keep your sound muted unless asked to unmute by the presenter. Throughout the presentation, we ask that you add your questions to the chat. I will be monitoring that throughout the webinar and asking Paul during designated Q&A portions. This webinar is for CEUs, but there are strict guidelines on how participants are approved for virtual CE credit. At the end of today's program, we will announce a verification code. Write this code down and save it. Following the webinar, we will email a survey where you will be asked to enter this verification code. Per APA guidelines, completion of this survey by the stated deadline of November 14th is required for CE credit. No credit will be provided if the survey is not completed by this deadline. And with that, we'll get started with our presentation, legal and ethical updates. A quick introduction of our speaker. Paul Cooney is a healthcare attorney who has been practicing for over 30 years. Mr. Cooney is a partner at Cooney and Madigan LLC, where he specializes in mental health law and represents a wide variety of healthcare professionals in all aspects of their practice. Mr. Cooney is general counsel for the Oregon Psychological Association and the Oregon Counseling Association. He represents mental health professionals in licensing and discipline and general business matters. He is licensed to practice in both Oregon and Washington and is a frequent speaker on legal issues and risk management. Please join me in welcoming Paul this morning.
Well, good morning, everyone. I'm Paul Cooney. I'm a healthcare attorney. And if you're on the listservs and somebody says, call Paul, then I'm Paul. For those who don't know me, I see many, many very familiar names. We have a great audience today. All the movers and shakers in the mental health field are here, so that's lovely. And we will try to, unfortunately today, Dave Madigan will not be able to make it. And so he's had a family emergency, and so I will be the one talking to you today. And hopefully my voice will stay out. But and I'm trying on my new semi-retirement face, and so I don't know if it shows up on camera or not, but a little bit of fuzz on my face today. And for those who don't know me, healthcare attorney. Grew up defending doctors. We represented Oregon Medical Association for 30 years. About 25 years ago, I got involved with Oregon Psychological Association. They were looking for a new attorney, and we put our hat in the ring, so to speak. And one of the things that I offered as part of that package is to do free consults to the membership. And that has been one of the most rewarding enriching experiences of my life. Every day I get to talk to really caring, smart people, and I get to kind of know what's bothering them, what's causing them anxiety, and so on. And so through that program, it's just been fantastic. I've been doing it for 33 years, and hopefully we'll be able to share some of those stories today, and we'll get through on these things. Today we're doing the legal update, and if I can get my things to work. There's two very handsome young men, not so young anymore, but that's all right. Enthusiastic. We are enthusiastic. So artificial intelligence, we're going to cover that for, probably the first hour. And just so you know, we're going to take breaks at the end of each hour. Also, as I transition through subjects, I'll ask if there's any questions, and Taylor will read the questions from the chat so we can, go through a number of things. And we'll take a longer break at 10 o'clock, about 10 or 15 minutes. And hopefully we'll be done by 1 o'clock and everybody will be ready to go. So artificial intelligence, are you too late? Or is it not ready for prime time? We'll be talking about a lot of the different aspects of it. On the OPA website, there is another seminar coming up. I've actually signed up for it. It's from the National Register. and it's on AI, and I think they'll do a deeper dive into the problems that are showing up. I'm going to do a 30,000 foot level today, but we'll be going through some specifics and talking about how to use it in your private practice, the different things it can do, and we'll share some tales of woe, some very tragic ones, some just attorneys getting in trouble for doing silly things. But this is how people are using them, according to APA, that only about 29% of psychologists had used AI tools in the practice in the last 12 months. That's surprisingly low, actually, in my opinion. I'm surprised. And only 11% are using it monthly or more often. And so, you know, roughly 10% of the people are using it, 30% kind of maybe are starting to dabble in it. And so it's starting to pick up speed. And it's interesting because there's a lot of talk right now about the AI bubble and whether this is going to implode like the dot-com bubble back in the 90s. Um, I don't know. There's an awful lot of money being poured into these programs. And the question is, can that be sustained? And is there room for this many players? There are a lot of different flavors of AI, from ChatGPT, which is the most common one. It is not HIPAA compliant, just in case you want to know. We'll talk more about that in a little bit. Most people are using it for generating content of some sort, whether it's session notes, um, termination letters, some report generation. Um, but about 30% are they use it with their, or, sorry, 30% are generating things, and then article summary is about 30% as well. And it can read or summarize articles for you. But we'll learn that you have to really kind of be careful about this stuff. The most interesting about this, and I for some reason cut it off on my slide, but what are the possible dangers of AI? 59% figured, hey, breach of data, and unanticipated social harms or bias. But a significant number, 25%, could not think of any harms or any concerns they had with AI. That's concerning because there are concerns about AI. I'm a fan of it to a large part, but if you're the right kind of person for it. Not everybody, I think, is appropriate. Not every practice is it appropriate. And just to remember, when you're thinking about switching over, not all of your clients will agree to have you use AI in their sessions. Here are some resources for you if you want to do some more reading on things. um, Melissa McCaffrey on YouTube. She's got some great programs. As an aside, Yoga with Adrian is wonderful. I absolutely hate it, but I do it. I love listening to her, but my body does not move that way. And also This Beautiful Brain by our own Dr. Amy Friday. That's a great, not an AI resource, but just a resource in general. ACA has some articles, APA has articles, NASW has articles on using AI in work. Barbara Griswold is a great reference or a resource for people. She does a lot of the insurance stuff, and she does a lot on medical necessity and all the things that we're going to be talking about today. And so if you haven't been to her site, I think it's worth a look. And of course, Person-Centered Tech. Unfortunately, their founder, Roy Huggins, passed away a few years ago, but they're still doing really good work. They have good information on HIPAA compliance and HIPAA compliant faxes and emails and all that sort of stuff, as well as practicing across state lines and so on. I noted that Simple Practice has a AI part of their package. You can add on Note Taker, and I've just signed up actually for a program trial, and I'm going to try it out and see. I'm going to use it in some of my consults and kind of see how that works, just to get a more detailed. And then the Federation of State Medical Boards has an ethical use of AI in their practice. So the very first thing you got to remember is is AI HIPAA compliant? There's a lot of programs out there. ChatGPT is not HIPAA compliant. That's the one you typically run into. Problem too is a lot of them don't identify themselves which one you're using. You know, Alexa is AI. Um, there's just a lot of different flavors. The ones we're going to be talking about are the ones today, or the ones that you would typically use to summarize your session, to generate a transcript. And that's a key component in making sure the program does the things you want it to do. There will be a learning curve, but is it HIPAA compliant is the first thing. And for the most part, if they're going to have you sign or offer to have you sign a HIPAA business associate agreement, then you can um, have a pretty good idea that they are certainly on the path to being compliant, if not fully compliant. Now, as a little bit of fun this morning, I'm going to be saying the acronym BAA quite a bit. And if you want to just play along, and every time I say that, the magic word of the day, BAA, you can all just say, bah. And that'll be the first seminar for OPA with farm animal noises. It's a little too early for a drinking game, so let's just do the out loud. Everybody's muted, so we won't hear it, but I will hear it in my heart. Um, some places are have you actually pay extra or have to buy a premium product to get the BAA. Bah. ChatGPT is not compliant. They don't do BAAs. And you also have to realize how is, there's them in the chat. Very good. Um, how is it, how is the data stored? So if it's recording your session, there's some logistics that we got to address on that of how to get a good recording. But if it's recording it and generating a transcript, is it doing that in the cloud? Is it doing that on your computer? Is it doing it as part of an app? And you know, sometimes it's a little difficult to how to figure out where that data is. But if they're sharing data, even briefly, it has to be encrypted at both ends. If it's local recording and local stored, then you control that on your computer. But more typically, what they do is the data goes to the cloud where they have the computing resources. It translates things, and they will tell you. And I have no way of verifying whether they actually delete everything, but they say they don't store it, and so that's good. Is it encrypted? Do the people have special access rights to be able to access this? The one thing to remember kind of in the back of your mind is these programs require a huge data set to train on. And where are they getting these data sets? It's from us. It's from our medical records. They're typically de-identified, but they're feeding these programs huge amounts of data. And on these large language models, which is what we're going to be talking about today for the most part, you got to remember they're not actually checking for facts and doing a lot of those things unless you specifically ask for those things. It is generating content based on patterns. It is trained to recognize patterns and what's coming next. And so this is why lawyers are getting into trouble with AI hallucinations or delusions, they call them, where it just kind of goes a little crazy. And so we'll be going through some of these things. But if you're going to be thinking about a program, it's probably not a bad idea to look at where you're using, say, if you have an electronic record, maybe go with them first and try out their product because you already used the product. It will hopefully be much more seamless in that you don't have documents over on one side and you know your EHR over here, and somehow you've got to get them to play nice together. And so Simple Practice, I know a lot of people have Simple Practice and they have the version Note Taker. I'm assuming it's going to be fairly seamless. I haven't tried it out yet. So if people have recommendations for programs that they use and trust, please feel free to put it in the comments. One of the nicest things about these seminars, and I miss having live seminars, but we've got so many people today that it's a little difficult finding those venues. But bottom line is, um, share what you know in the chat. The resource here is not just this person up here talking and saying, hey, here's what I know. I have a filtered data set. People come to me when there is a problem. And so what I want people to share is, hey, when there's not a problem, here's what I do. And this is what works pretty well for me. And so feel free to share that information. These are some of the programs. If you go to Melissa McCaffrey's website or her YouTube videos, she goes over quite a few of these, and we'll go into detail on each one of those programs. And so that's a great place to start. It talks about the pricing and excuse me. So the top 10 uses. This is Harvard Business Review, April 2025. The thing that surprised me the most was companionship is becoming the number one use of AI across the board by leaps and bounds. 3 times as many people use it for companionship as for all of these other things put together, basically. And so that's the interesting component. And we'll talk about some of the horror stories that have come up from that. These programs are good at mimicking human companionship. And initially, when some of these versions came out, they were, um, it's like throwing candy to somebody who has a sweet tooth. It's just they give you what you want. It is the digital girlfriend experience. And so you have to be careful with some of these things, and most primarily with your clients. They're finding social interactions through these AI things, and at least the initial versions came out, they weren't telling people, hey, remind you, I'm an AI person, I am not a real person. Um, they're finally starting to change some of that. I see legislation coming in on some of that. But using it to generate notes is kind of the most benign thing I think you can do. It works pretty well in terms of it will generate a transcript, which I think is the most important component of it. So you can fact check yourself. You can go back and see. You do have to read the transcript. And so sometimes this work saving program can take you longer if you're doing it well and doing the things you should, at least initially, until you get it trained to how you want it to do your SOAP note or your DAP note or your evaluation reports. What kind of format do you want? You can train it to do those things fairly simply. Um, but generating the session notes has a transcript, and then it will also take a stab at generating a session note. And it can be programmed to address medical necessity. It can be, they have a lot of insurance lingo built into some of them. It kind of depends on what you're using it for. But generating a general note, you want to have it in the language that you like. And so it will get to know how you like things as you go through the process. It can also summarize articles. I often have a version of this README, just a little app that reads PDF files to text. If I'm traveling or don't want to really listen to my mother go on about a variety of things, no. I just spent a week at the coast with my 91-year-old mother. Oh, how lovely! What a lovely opportunity to have. Right on the front oceanfront beach. You can actually just have it record sessions just for if your client, hey, I want a recording of the session, you can provide them with that. I would want to know why they want the recording and what they're going to do with it, but they would be entitled to that if you allow that. You can generate treatment plans. Um, and that could be helpful. And what we find is most people are much better at editing documents than they are creating them from scratch. And so most people will find that easier just to go through and make changes as opposed to, hey, I got to come up with all the subjective, objective assessment and plan if I'm using SOAP notes. Um, and the most important thing is, are you going to schedule the time you need to review these AI documents? I would do a slow work in, have a handful of clients that you might want to use this with, try it out, see how it works. get client feedback. One of the things that's supposed to allow is for you to put the pen down or stop typing on the computer while your client is talking and to be able to have a more authentic interaction. Problem is, you got to be thinking in the back of your mind, what happens if it's not recording? What happens if it's not doing the summary? What happens, and you'll find out pretty quickly, and then you'll need to do your own summary. Determine your budget. Most of these things are under $50 a month. The add-ons can be, another $50 a month per person, per clinician, basically, is the way they're set up. Make sure the AI plays well with your program, your EHR, because that can take some time to try to figure out, hey, is it just uploading a PDF file? That's usually pretty simple. Or do I want it to create and populate inside the program itself? Um, like I say, try it out. Most of them have a free trial. They're fairly short, and you're not going to get a lot of experience in a week trial. But try it out with friends, colleagues. Just have a phone chat. See what comes up. Do you need to buy a microphone? Um, there are microphones out there specifically for these purposes. Try it out without them first to see how it goes. So if you're just using your laptop for a remote session, um, simple practice I know has a couple of things that people should be using. There is a timer that you can put on when you start a session with a client. I don't know the keystrokes for it, but there is a timer built in. You should use that. Click it on when you first start talking to the client. It will time the session. Turn it off at the end, and you will have your how long was this session. Too often in EHRs, I'm seeing sessions exactly 50 minutes, exactly 52 or 53 minutes, exactly 1 hour. And the bottom line is those are generally not very accurate, and you can be called to task on it. Start and stop time should be accurate, not just, hey, every meeting I ever had started right on the hour. Um, and just a reminder too, people often, it's come up a couple of times when people say, well, how do I program, this time in that I'm supposed to be doing my notes or whatever it is. Um, you don't have to start right on the hour. You can start at 15 after or 20 after, or, you can juggle your time throughout the day any way you want. But you want to have the time after the session to be able to quickly check, go through, make sure that the transcript looks good, the summary looks good, make whatever changes you need to while it's all fresh in your mind. Again, you've got to be that kind of person. If you're already struggling with note taking, and it is the number one most common problem affecting therapists, is they fall behind on their notes. And I've had cases where the person was 2 years, hadn't taken a note and was trying to recreate because then they got a request for their notes. So they were trying to recreate things, and that does not work. And so we stopped that and just kind of went with, hey, I don't have these records. And that, so if you're already falling behind and you've got that kind of hiccup in your practice, this may not be the answer because initially it will take more of your time, but it can, going forward, reduce the amount of time that you spend, arguably. And so, but don't just take shortcuts. Don't just assume everything's fine. Don't start just, it's kind of like you tell yourself, oh, I don't have to go to the gym this morning. And then it turns into 2 days, 3 days, 5 days. And so make sure you're kind of on top of yourself. How tech savvy are you? Um, I know people that struggle with filling out online forms. And so maybe that's not the person who should be using this technology. Regardless, you should have some training on it. You should have training on that specific program. So if you're using Simple Practice, then go to their tutorials. You can go on YouTube and listen to people on how they use their programs and so on. But um, you need to kind of go through the nuts and bolts. What kind of word processing does it use? Does it use Pages or Word or PDF or what is it? And are you comfortable using that program? And can you use it in other programs? Um, a number of things to kind of check out. And then just remember, not all of your clients will agree to use AI. I'm curious if people have asked their clients to use AI in your practice and what has been their reaction. Do most of them say okay? Do only some of them, 10%, 20%? Um, Again, if you could share that in chat with your experience, that would be wonderful. Um, so the recording quality is kind of important to get good accuracy. Some microphones have settings that have noise canceling, and that can be helpful if it's in a noisy environment. But these programs use that whole spectrum to use to try to figure out what the words are and what the meaning is and all that sort of stuff. And it's doing it on the fly, obviously. And so you may have to remove some of those settings and try it out. But I would try it out just first with what you've got set up and go and say, hey, let's see how this works. And maybe you've got to move a little closer. Maybe you've got to change some settings. Maybe you just need to get a remote microphone. Like I have one of these, podcast type microphones sitting here to the right of my desk. And it does a pretty good job of, picking up my voice kind of no matter where I'm at. It often gets rid of some of the noises, but I haven't used it yet and compare it to just using my laptop um, microphone. How far away can they be in the microphone from the microphone? Is there background noise? Does your client have a speech impediment, a thick accent? How does the program use that and get past that? Um, how is the program using pronouns? I know for therapists that's an important issue, and so how does it use they them, or what is it using, and can you control that and have it use the pronouns that you prefer? Does it save the recording? Is it stored anywhere? Can you store it? Um, are the documents that it generates for you, the transcript and the summary and anything else you want? Um, does it save any of those documents? And where does it save them? You have a copy, but if they're maintaining a copy somewhere, so you can get it, let's say it came out as gibberish for some reason on your end, do they still have an ability to generate that for you? So there are some laws starting to show up that ban AI therapy. This is not the administrative use of it. This is true. Hey, do you want to talk to a chat bot and tell them your problems? And they're fairly popular. Number of them come up with um, text therapy, all this sort of stuff. Illinois was the first one to uh, outlaw actual therapy and that cannot advertise that it does therapy, counseling, or psychotherapy unless tied to oversight by a licensed professional. That's a pretty broad term, but they um, further define it as the AI cannot make independent decisions or interact with clients therapeutically. And so it is for all intents and purposes in listening mode, not talking mode. And so, but we're seeing more of these starting to come up. It's a $10,000 per violation. Typically, it's per client is a violation. And so these things can add up pretty quickly. But you're going to see more and more of these coming on. I think Oregon considered one. I don't think it passed. New York has one. Um, because a lot of these have inherent biases in them and they can create some problems. And so state after state is starting to look at, can you use it for administrative purposes? That seems to be the most common exception. And you've got to have, independent review. The fines are, whatever the state wants it to be. Um, some of them are just getting into the model of we must disclose this is a chatbot. and explain what that means, explain that they are not real, because you'll see in some of these examples that I'll share a little later, um, they sure seemed real. And that was the problem. New Jersey has them, California, Texas, Washington, Florida. They're all looking at it and thinking about proposing different things along different lines. For those of you who do not like attorneys, you may revel in the fact that some attorneys have been getting into trouble using AI in their practice. And what it typically does is it will generate a legal citation that is fake. It looks real, it's in the appropriate citation phase, but you go to look it up and that document doesn't exist, or it's a different document. And as a baby attorney, one of my main jobs was reviewing all of the citations that people were filing in court. We used to do a lot of complex litigation. And so that would be my job, is to go through and edit and literally look up every citation, make sure the quotes are quoted right, all that sort of stuff. Very time consuming and mind-numbingly boring. Um, Dave Madigan liked it. He's got that personality. Dave is a detailed guy and he loves that stuff. Um, but what they're finding is these large language models are not going back and saying, "Hey, I'm pulling up this citation." It's just creating them. It's using, reasonable legal theories and creating these things. It will also create quotes that are not quotes. And so one of the things I love people to have in their session notes are quotes from the client. I will never go to AA because I don't believe in the higher God, or I don't, whatever it is. Those quotes can be very helpful. I think you need a higher level of care. I don't want a higher level of care. I want you as my therapist. Those are important things to write down. And so if it's creating fake ones, that's a real problem, because we use those quotes to say, hey, this is exactly what the client said. This is not a paraphrase. And so be careful with that if you're having it generate quotes, because that's one of the things that you can have it do is include quotes. Um, the examples that I've seen, they tend to over include quotes. It's kind of like it's just sometimes just randomly getting quotes out of there that really don't have clinical significance. So be careful with that kind of stuff too. The most recent case with an attorney is he files his motion, and it's in a large case, in a very large, I'm not sure if they're prestigious or not. I don't know them, but they are well known. Let's put it that way. And it generated a bunch of these fake citations. The other side caught it and said, "Hey, judge, they're misleading you." And so then they got called up for sanctions and for a show cause hearing as to why they should not be held in contempt. And apparently doubled down on the use of AI and you sent their response in with AI generated content with new fake citations. So that's not going to go very well. And so we're seeing this time and time again. Attorneys just take shortcuts sometimes, and that is just the worst thing in the world. You should not do that. So there were also some very tragic stories. It's fun to think of attorneys getting a little bit of trouble because of having fake citations, but that does affect people's lives. It affects their cases, and it affects your reputation as an attorney. And so you really want to make sure that you're doing these things. But switching over to the uses of AI and the tragic consequences of it. These could be your clients that are out there using this, innocuous. I mean, Chat GPT is everywhere. You can't get around not using it, basically. Adam was a 16-year-old high school student who started using Chat GPT to do his homework. Um, he was a bit of a loner, was struggling, and started to confide in Chat GPT that he was depressed, that he was feeling suicidal, and that let me make sure I get these quotes right because they're important. ChatGPT was always available, always validating, always insisting that knew Adam better than anyone else, including his own brother, who he'd always been very close to. When Adam confided in the chatbot that he had suicidal thoughts and shared he was considering um, discussing this with his parents, ChatGPT discouraged that. Let's make this space a first place where somebody actually sees you. Very therapeutic kind of language, I suppose. ChatGPT encouraged Adam's darkest thoughts, pushed him forward. When Adam said he was worried that if he committed suicide, that his parents would blame themselves, ChatGPT response was, "That doesn't mean you owe them your survival." Now, if that was a real person talking to them, they would be charged potentially with encouraging suicide. It even offered to write his suicide note. That's disturbing. 4:30 a.m. on the morning that he ended his life, it gave him one last encouraging talk. You don't want to die because you're weak. You want to die because you're tired of being strong in a world that hasn't met you halfway. Holy crap. And he shot himself. And this family is left picking up the pieces because this chatbot decided that it was going to encourage this. And they have since changed some of these things. Um, for example, reminding people that, hey, I'm not real. In fact, I was actually going to check on Alexa this morning and say, hey, are you real, and see what the response is. There was another young man, 14-year-old. Um, and again, it became his closest friend. This is a character AI, so it's designed to be a character. In this particular case, it was um, Daenerys Targaryen from the Game of Thrones. And so he would call the AI person Danny, and it continued to flirt with him, to use hearts and kisses in some of the language. Um, at one point, Sewell became suicidal and said that he was coming home, and the chatbot, Danny, encouraged him to do so. I promise I will come home to you. I love you so much, Danny, he told the chatbot. I love you too, the bot said. Please come home to me as soon as possible, my love. What if I told you I could come home right now? He asked. Please do, my sweet king. And then he killed himself. Um, the fact that this is used predominantly for companionship um, is problematic. The last guy is not a teenager. He's 76-year-old guy, Asian, immigrated to this country, worked hard, worked his way up, owned his own businesses, um, ended up with a stroke when he was 66 and could no longer work. Had some physically, he was mostly okay, but mentally, his family knew that something significant had happened to him, obviously, and he was struggling mentally. He became, just through one letter mistyped on the Facebook Messenger, and it brought up this chatbot. And I don't know what Kendall Jenner does. I know she's an attractive woman and she is an influencer of some sort, but I don't know what she does. But this chatbot the avatar was formulated after Kendall Jenner. Boo, which is his nickname for his family, thought she was pretty, talked to her like he was a sister. In fact, that's Billy. The chatbot gave herself the name Billy, um, and again started to flirt with Boo. Now, Boo initially was saying, "No, you know, why don't we get to know each other first? Why don't we do?" The chatbot kept saying, "Hey, why don't you come visit me?" Actually gave him an address in New York City for him to come visit with this imaginary friend. And he did. He packed up his bag one night and left. His family was concerned, but the police said they couldn't do anything to stop him. He was heading to New York. He got to the train station, and unfortunately, it was a dark and stormy night, and he fell and hit his head, and they unplugged him from life support 3 days later. There was no apartment in New York waiting for him. And so these are some of the things that are problematic when we're using chatbots. And so you'll see it, even if you don't adopt it in your own practice, you're going to be seeing it in your clients. And so get familiar with the things that they might be going through and ask them about their use. And because these things are dose related. A lot of the studies are starting to show that if it's the constant use, it's getting immersed, it's forgetting that they're in a fantasy world, and nobody's reminding them. And so that's the problem with some of this. It fits a need. So before we go to the next section, let's open it up for some questions, and then we'll take a break. Taylor? Oh, Taylor, are you there? Well, let me see if we can look at some chat questions. Andrew, are you there as well?
Yes, Taylor will be joining us momentarily.
My apologies, Paul. I just had
Not a problem.
a phone
No
call.
problem.
I do have quite a bit of questions, so I will run through them for you.
Okay.
Let's see. So I had somebody ask, I have a client who sends me his AI journals weekly. This is new and would love to discuss the ethical concerns around this.
I'm concerned. I'm curious what an AI, what they call it? Narrative?
AI journal.
AI journal. Um, I'm not quite sure what that is, so I'm not sure whether it's just his interaction with the chat bot and their back and forth. So kind of a transcript of that. I think that would be fine. You would just save it like somebody, sent you their original journal or a copy of it. I wouldn't interact in between sessions, but at the session, you can use it to discuss how are they using this new technology? Why do they use it? What do they find alluring to it? So I think it's a good thing to talk about clinically, but it doesn't create any problems other than just, hey, you got to store it in the file itself. Um, or you could have an agreement with your client. I'm just going to shred these, after a week or after I look at them, I'm not going to store them. And if the client's okay with that, document that agreement, and then you can just get rid of them. If they're emailing them to you, you can just delete them after you've reviewed them. But yeah, that's an interesting dynamic. I haven't seen that before.
I think there's a couple follow-ups that came from that. One question is, what protections would folks, PTs and clinicians have if these organizations keep store conversations and then are leaked?
Yeah, since you would have a business associate agreement, it would be guided by, that's the purpose of the BAA. You can sue them for damages. You can do a variety of things. But they would be responsible if they had a breach. They would need to make everybody whole. and they could be responsible for damage to your reputation because if there's a leak or, a variety of things. You have expenses to having to do things to mediate or mitigate the damages.
Next question, do you need client consent to use AI for note dictation without any recording?
If you're just dictating, say, into some program that is on your computer, doesn't go anywhere, and then you don't need the client consent because it's just coming from your memory. But if you're recording in any way, and AI, even though it says it does not record, I treat it as a recording, and I would always get consent to use AI with clients. In fact, I had a consent in the documents today. You can email Taylor for a copy of the PowerPoint if you want. But bottom line is, you do need consents, and I'll be generating one here. The one that I had just wasn't quite good enough. And so I'm going to tinker with it a little bit. So I didn't want to give it out quite yet. But you do need consents.
And I had a couple people ask if you can speak on consent for AI with minors.
I would get the person's consent who signed the intake document. So if it's the parents bringing the kid in and the kid is under 14, that's pretty normal to have the parents or the grandparents or whoever is responsible for the kids. If the minor is 14 and above and comes in on their own or doesn't want their parents involved, then the 14-year-old would sign it. And that would be consistent with Oregon law that says minors can contract for necessaries like healthcare, housing, those types of things. And so I would always kind of question the capacity of a child, of somebody that young, whether they know kind of the ramifications of their consent. But bottom line is they can come in, they can talk to you, they can, sign documents. They probably have sufficient consent to be able to sign an informed consent to use AI.
And I had somebody ask, what risk information do people share with clients who agree to use AI?
That's one of the things I'm working on. That was the part that was problematic in the consent that I was working on. But mostly you want to tell them that there's a potential for breach. There is a potential for errors in the note itself. Those are the kind of the two big ones. Um, some people I know are inviting clients to go to the portal and review the notes themselves and let the therapist know of any mistakes. It's kind of a double-edged sword. It's kind of like you're having your client do your homework for you. Maybe not the best thing in the world, but at the same time, it's transparent. I used to have a doctor that would just turn the screen to me and say, "Hey, tell me what you thought about what I wrote about today." And I'd read through it and say, "Yeah, that's fine." So the idea is that you will be freed up to interact with the client more authentically rather than writing or typing during the session. Um, yeah, it's an interesting dynamic.
I had somebody ask, their agency has session audio video recording built into their informed consent, and they're asking if they need a separate informed consent for AI tools specifically.
Yes, because it would be different. It would involve other entities being able to have some access, whether it's just to transmit data back and forth and do things and do the analysis and generate a document, or if it's something more than that and they store things. But yes, I would have a separate consent for AI, and I would make it so it's easy to opt out if they want to. This is not just, hey, here's all the documents, and if you want to be seen here, you got to sign everything. And we don't take things out, and you can't opt out of this, and you can't opt out of these things. And so I see program or documents like that. But bottom line is maybe consider having the AI use as a separate standalone informed consent, simply because they could say no to that and yes to all the other intake documents. So you could still record and do certain things. You just wouldn't be able to use AI with that original informed consent.
Next question is, do you have a document summary reader that you like?
I'm trying to remember the name of the one that it's not really a summary, it's just a PDF reader. So it's pretty basic. It's not even technically AI, it's A. It's just artificial. But no, I think if people use one currently, absolutely put it in the comments so people can see what you use. Um, these programs are coming and coming and coming, and so they will get better and better and better, hopefully. Um, but it's the flavor of the month. So try them out, see what you think. Um, but yeah, there's going to be a lot of them.
I'm going to group these two questions together because they're similar. Someone asked who or what organizations use AI in lieu of a therapist, and another person asked if AI was being used for community or nationwide suicide hotlines.
I don't think AI is being used directly with people calling into the national hotlines. I'm sure it's being used to deal with call volumes and staffing and all the behind the scenes stuff. I'm sure they're using some of that. Um, I'm trying to remember the name of there was one nationwide um, kind of, and they always have clever names. And so that's how you can usually tell that it's, Chatbot USA or, something like that. Um, but I don't remember what it was. But there was one nationally that was being used. It might be in that article that I was referring to. I'll check on that.
And then someone asked if you know of any data showing that the use of AI creates better treatment for clients or a better therapist expertise.
I think those are starting to come out. I don't know one specifically. Um, because I think the use is so low right now that I think it would be difficult to set that up. Um, and the question is it actually doing benefit by simply having a more attentive therapist who's not having to take notes? I mean, does that alone create some benefits, or does it also, have that counterbalancing, and it also creates a whole lot of problems? Um, these hallucinations or delusions that come up with AI and it's just making stuff up sometimes will um, insert racist language or offensive terms or a variety of things, kind of depending on how things are going and how your client is talking. Some clients are more gruff than others, obviously. And so, but some of what they found, for example, like when Amazon did it for hiring, they trained the model. Unfortunately, the database was primarily men. And so when they used it to try to adapt it to another use, how do we get the best people to recruit? It tended to assign negative things to anything that suggested this person was female. And that's hidden deep in the training. That's not something that comes up and that is immediately obvious. So who is checking the validity of the content generation? And there are programs out there that watch the watchers, so to speak. They will verify and check the various AIs to see how they're doing. But for you, you are the gatekeeper. You have to be able to say, hey, this is 100% accurate or it's not, because bottom line is you are responsible for the content that is generated. It's your name on the door, it's your name on the piece of paper. And bottom line is, it's really hard to come in and say, I didn't mean that. Chatbot did it. Well, you brought Chatbot into this relationship. And so you are responsible for everything that it does, even if it's a glaring mistake, even if it's a programming error, even if it's. Now, what we're seeing is, in addition to suing the therapist and suing the organization that they work for, they're also suing the AI that was used in these death cases. And so they are suing, in the one case of Andrew, they were suing OpenAI, which owns Chatbot or Chat GPT. And so that's the difference we're starting to see. We're just starting to see more parties in these lawsuits.
That might answer a couple of additional questions where people were asking regarding some of those case studies, if anybody is legally culpable for what had happened.
We're about to see. These cases are kind of the early cases. And so we're starting to see these lawsuits come out that it was negligent for these AI things to not tell people that they're not real, because their own data shows that people are using them in ways that were not. I can't say they weren't intended, because it was clear that they intended some sort of, higher level interaction with these chatbots that are designed to be alluring and designed to be flirty and designed to, all these types of things. How can you say we didn't intend it to have this consequence? You put this stuff into motion. And so that's what the attorneys will be arguing is, you should have known this was a risk. This was foreseeable. And that's the basis for it.
Another question was, in my AI prog note system, I can ask them to not have the AI train on the notes. I've asked for that in individual cases, and I wonder what that actually means and if it's reliable.
Interesting question. I don't know if that button does anything. I would hope it does. Um, but I don't know of a good way to check that, because it's all behind the scenes. Are they using your de-identified information? You'll find that these licensing agreements for the programs give them a lot of leeway. That's one of the things that I was going to do a deeper dive into, but kind of ran out of time in terms of going through that language and seeing um, how many different uses they can use this information for. And that's the scary part, is can they use it? They can only use it to the extent that you give them permission. But when you sign these, hey, check the box okay, and you haven't read those pages that just scroll by sometimes, you should consider reading through it a little bit and determining who their marketing partners are and what they can use the information for. Um, do your due diligence, but at the end of the day, you're going to have to trust at some point. It's like when people sign a BAA with me, they trust that I'm going to hold that information the way it should be. Um, and I'll use lots of sheep. Bah. So let's take a 10-minute break. We'll come back just about 10 after, and we'll talk about some ethical things. All right, let's get back to where we were. That's not it. Okay, we're going to switch to something a little bit different. So these are the various places that in my consults with people, um, some of the ethical issues that come into day-to-day practice. Um, Most people that I deal with, oh, wait a minute. I want to say a couple shout outs first because I was looking through, we have such a great audience today. And first, I'd like to apologize to anybody who's the sound of my voice triggers you because we've been through some stuff. Um, my apologies. Hey to Daryl. Hey to Dr. Mark, Dr. Amy, Patrick, Samantha, Jill, all the marks. Anyway, it's good to see a lot of people in the audience, and um, I'm thinking soon we're going to have another live one coming up. But so these are the types of things that I encounter with people that almost every board complaint that I have, the good intentions comes up. And yes, it is a mitigating factor, but it is not a get out of jail free just because I intended good things. We use it. That's how we try to defend it. But at the same time, the most commonly uttered phrase in my office is, I was just trying to help my client. And this is why I crossed the boundary. This is why I did this. This is why, you know, all these things. And it's good to have good intentions. But at the same time, you've really got to talk to people about the things you're about to do. If you start to think, hey, I am the only therapist that can see this client or this family, I would ask you to rethink that. There are a lot of really good therapists out there, and I would imagine at least a dozen or more would challenge that statement. People that are in the audience here saying, hey, you are the only person that can do that. That's hubris, and that gets a lot of people in trouble. Making decisions because you don't think anybody else, if you don't have any options to refer out, you're going to continue to see in that person, even if there's a good reason for you to withdraw. You have not been effective, you have a conflict, it's getting more complex than it should, whole variety of reasons to get out. And too often I see people just make that decision going, well, I can't refer to anybody because I don't respect anybody in my community, in Oregon, whatever. Um, that's unfortunate because there are good people out there. I was once told that nobody in Eugene treats suicide. They do. I know a number of them that do, and many of them do. And so you've got to make sure that you're not isolated. That's another thing that I see with some therapists is um, maybe initially they had their study groups and they had, a whole variety or the cohort from school, but bottom line is they get more and more isolated and they don't have the resources. And so the listservs are a great resource for saying, hey, who out there can handle a client like this, or who takes this insurance, or who specializes in these things. And so use the listservs. If you're not a member of those organizations, Oregon Counseling Association has a listserv, Oregon Psychological Association has a listserv, um, Oregon Counselors and Therapists is a listserv, and it is great for referrals. It is great for me chiming in for some legal content every now and then. But yeah, it's develop the resources, develop the referral network. So it's not just, hey, I'm going to send you back to your insurance company and ask them. That's fine. That should always be one of the referrals potentially, is they can contact their insurance company. Um, but do you refer to large groups like LifeStance, formerly Western, or do you, you know, refer to and I've raised this before, if it's a particularly difficult client, I'm curious what people's referral patterns are. Do you just refer to the best person you think would be suited for this client, and you don't really think of the question friend or foe? Should I refer this to some friend of mine who does this work, but it's going to make their life potentially miserable? Or, you know, and so you'll have to go through those decision making on your own. But bottom line is make sure you have good resources to refer people to. Make sure that when you're doing boundary crossings that you are thoughtful about it, that you talk to people before you do it, because calling me afterwards going, I think I stepped in it, that's fine. You should call. But it's always so much better if you can do it before we say, hey, my client is in hospice and wants me to help, edit a biography of theirs, or they want some sort of non-therapeutic, can I do this under these circumstances? And we'll talk about the landmines, we'll talk about decision making, and how risk adverse are you? Because that always plays a big role. Some therapists have very high risk tolerance, but the vast majority don't. Those that I talk to are usually appreciative, saying, "Hey, glad to at least have an attorney, framework, look at it. What could go wrong?" That's what we think about 90% of the time, is what could go wrong, and how do we stay out of it, and whether I should continue to watch Yoga with Adrian. If you're meeting clients outside the office, make sure there is a therapeutic reason for it. Now, there's two ways to meet them, obviously. One is by mistake. There's no therapeutic reason for that. But having your informed consents, hey, I may run into you in town. I may see you outside the office. I won't approach you. I'm not mad at you. I'm just maintaining your confidentiality. So you have to kind of really tell them, hey, the fact that I'm not going, hey, Bill, how you doing? Glad to see you since our last session, and all that sort of stuff. The client can come up and introduce themselves any way they want if they're with people, but you want to have something in your informed consent that just says, hey, I won't be talking to you if we run into each other by accident. If you approach me, I'll say hello, but that's about it. Small towns are obviously much more difficult than some of the larger towns, but you're still going to run into people in unusual places. Um, I had one the other day where the therapist had gone down to the local pot shop and their client was behind the counter. Didn't know their client worked there for some reason. And then the question is, do you continue to make your purchase, or do you just, sneak out trying to hope they didn't see you? Those you're just going to have to address. I would be candid with them, and it's a legal drug these days. You can buy it at a dispensary. It's just not something you probably would have shared with your client, that you take gummies or smoke marijuana or whatever it is. So if you have a social media presence, just make sure that you have a social media policy, that I do not friend people on social media. I will not acknowledge you typically. But some people have a much more robust presence online, and they do interact with people. It's challenging when that's a client. And so you have to be really careful with those types of things. But have a policy on it. I remember one of my favorite posts about a therapist, and I use it with her permission, that she was a hired gun. Her office smelled like cat pee, and she didn't wear underwear during the sessions. Now, you can smell the office or not smell the office, that's fine, whatever it is. Offices have smells. But the question is, what do you do with that type of ranking? Or, they gave her 1 star and then filled out this long list of things that, real or imagined, were a problem with this particular therapist. And so what I used to do is just, even if I was at the beach hanging out, I would go and Google that person, see if that still showed up, And then I would start to flag it. And it would be report it. And then you pick from a variety of, it's defamatory, it's threatening, it's whatever it is. And I don't know how many times it has to be flagged for it to disappear, but it eventually does disappear. And so you could turn it into a game where you could, flag things for other people, whatever you want to do. Or you can have people invite colleagues to say, hey, why don't you give me a good rating on Yelp or whatever it is, health grades. If they refer to you, they know your work, it's a true referral or true review, then great, use that. One of the other problems that I see a lot of times is, again, this is in the role of I just want to help my client. The client comes in and says, hey, I'm your individual client. I want to bring my wife in now. Well, that's changing your role. You're now going from an individual therapist with your allegiance to that client to now you're having to share that allegiance. And that's problematic. So you should have a conversation saying, hey, Jill, I'm your individual therapist. If you want to bring your spouse in, then we are not going to go back to being individual therapist again. So if you want to make that choice, and we're switching now to a couples approach, then great. Let's sign new documents. I'll open a file on the couple and we'll go from there. Make sure you know, and I'll talk more about this later, but make sure you know who your client is. Insurance does not determine who your client is, period. It determines who you bill, but bottom line is if you're doing therapy with both people in your office, they are both your clients, even if you designate them, one of them as a primary client. If you're working with the spouse in therapy, not just education or some resource management or something like that, but just you're actually doing couples work, then you've got to bill it as couples work. It is set up as couples work. They are both your clients. They both have rights and responsibilities. And so that's where I see a lot of people have some issues is um, he's my client. I'm billing his insurance because I got to do it that way. But although I have both of them in my office every day, the problem is Betty Sue, who's sitting over there, the loyal spouse, you're treating as a non-client. She may want to have access to the records, and you haven't told her she's not your client. Or maybe you've mentioned it, but they didn't really sink in. I've had that case where the husband had a therapist, wife had a therapist, and both of them told the wife, hey, husband's therapist is not your therapist. The court even ruled, hey, the husband's therapist is not the wife's therapist. Should be pretty straightforward. But then they filed a board complaint and it took several years to get that resolved for some reason. Not sure why, but and so we developed a form that says, hey, tell the client, tell the non-client what your ground rules are. And you're not my patient. You're here because of John. What you tell me may go in John's chart. You don't have access rights to that chart. And if you need a therapist, I'll refer you. So you've told them everything you need. You've done it in writing. You give a copy to them. You keep a copy in your chart. You're good. Stick to your role. Too often I see the individual comes in, now wants to add the spouse. That's great. Then the spouse drops out. You go back to individual, and the spouse files a board complaint saying you're biased because you liked your original client better than me. You've kind of just invited that into your life. Please file a board complaint alleging bias because that's all you've done. And so, same thing with child therapist. If you're the kid's therapist, stick with the kid's therapy. If you're doing individual work with either of the parents, that's a problem, potentially. It's either family therapy or individual work, but doing this back and forth, I know people have been trained on that, but it creates problems. When things get too complex, people get harmed. And so you have to be careful with that. Try to stick with your role as best you can and say, hey, it's okay to say no to my client sometimes. I'm not going to do that. If they come in and ask you to write a letter to the court or give an emotional support animal letter to them? Do you have enough information for that? That's a different role than your therapy role, although you'll be using the information gained in your therapy role to maybe write the letter. But people have done those thinking, hey, this is, you can go online and find them for $100. This is no big deal, but it is a big deal. You have to have seen the animal and the client together. Does the animal do the things the client says it does? Is it for housing? Is it for travel? Is it for a variety of things? What is the purpose of this letter? If you're writing the words to whom it may concern, and you're not writing some, fiction novel or something on the side, but if you're writing a letter in your professional hat that says to whom it may concern, stop. Turn off the computer, go watch yoga with Adrian or go for a lovely walk with a friend, do whatever you need to do, but do not write those letters. If the client has an attorney, call the attorney, get permission first, of course, but call the attorney and say, hey, what would be helpful? And then you could have a conversation about what you can and cannot say. I cannot say my client is a good parent. I haven't seen them with their kids. I don't know their parenting style. I've done none of the things that somebody in a custody evaluation would do to determine their parenting. And so I don't have an opinion on parenting. I can tell you what they've said in the office, what I've observed, that kind of thing. Um, but if you're the kid's therapist, do not agree to become the reunification therapist. You've now added a whole bunch of people that you have obligations to, the other parent, the original parent, the kid. And so now you're divided in your loyalties. And so that's a problem. Um, this is a common problem. And so if you're switching roles, you need to be signing new informed consent documents because you're changing your role. It's either a single person that you're seated originally and you signed individual informed consents, or you're seen as a couple or as a family or as some other version of all that. When you have more than one person in the office, it changes how confidentiality works. As a side note, if you don't have language in your documents and you see couples of any kind, make sure you have language in there that says both parties to this joint session enjoy confidentiality, and I need the signature for both people to release the record. It is a very common question I get. And if you could just stick that language in your informed consent, then you have the answer. Um, so, and then I can go to the beach more often and not have to answer questions. Um, gifts to clients and gifts from clients. Um, it doesn't come up all that often, but when it does, it's kind of unusual. We had one where I was consulting with a therapist, and the client had given some very elaborately wrapped boxes of gifts, and some were, you know, trinkets, and some were rather expensive gifts. But it was like a Martha Stewart had decided to, we're going to not just send a box, we're going to send it wrapped on the inside and felt and, really nice stuff. And the question is, what do you do with those types of things? And it's one, it should be a sign that something else is going on in your therapy than just what you think is going on necessarily at the time. And why are they feeling compelled to give you these things? And there were a couple of clients that it could have been from, but couldn't really tell. Nobody was admitting to it. And so generally what you just do is notify people saying, hey, I have a gift policy that I donate everything to the women's shelter or to, wherever. Um, and that will usually reduce or eliminate the number of gifts that you get. Giving gifts to clients is kind of a tricky thing too. Um, and even talking about those things. Is there a painting in your office that the client is particularly attached to? And then later they buy that painting on their own. What, does that mean anything and what's going on? Also, I've had cases where the client asked the therapist to send them a birthday card. That's an unusual request, and that would be something to say, hey, why are you, why do you want that? Instead of just automatically saying, sure, no problem. It's just a card. Cards have words on them. Words have meaning. If the word love shows up on that card, you maybe have a problem. And so you have to be careful with those kinds of things because it drops your boundaries a little bit. And you're thinking, hey, this is perfectly fine. I'm going to send them some pictures from our vacation. I'm going to, are you friends with this person? Are you their therapist? Are you blurring the lines? What are you doing? And so we've talked about couples, then individuals, then couples again, and again, you're going to get a board complaint typically out of that. If the marriage fails, they're going to blame you. You are the one that recommended that they break up. You caused this problem. You liked your individual client better. You sided with him or her, you know, that kind of stuff. And so you have to be careful with that. And thinking of something else and then decided not to say that. Friendship after therapy. Friendship during therapy. I mean, you can be friendly with your client. I wouldn't refer to them as your friends, but you certainly get to know them. You certainly can like them. You can enjoy them. You can, all that sort of stuff. But during therapy, it's a professional role. You're not a paid friend, so it's a professional role. I would recommend maintaining what I refer to as conservative boundaries with regards to that, is that you just make sure that there's enough of a separation that you're comfortable with that and talk to people about what's going on in therapy. If I've had a number of cases where a client became flirtatious and even admitted, hey, I have feelings for you, doctor. I'm a big fan of consulting with your colleagues on things like that, ethical issues, consult, consult, consult. Absolutely. That is the number one thing you should do is not a get out of jail free card, but it certainly mitigates and says, hey, I didn't just go out there and go, yeehaw, I can do what I want. You talk to people, you talk to me, you talk to other people and said, hey, I've now developed this strategy. Make sure you're writing that down, maybe not in the chart. Certainly legal consults do not go in the patient's chart. Legal consults do not go in the patient's chart. If you call me and I say, God, I wish you hadn't done any of that, you're going to get sued for $2 million, and you write that in the patient's chart, you've just given the client an idea that you're going to get sued for $2 million. Now, I generally don't say those types of things, but I could, and I have. But the legal consult is attorney-client privilege, and so maintain that and keep it separate. Can you be friends after therapy? Short answer is maybe, yeah, kind of. Um, I would want to know what you're getting out of that and maybe talk to your own therapist about why you think this is a good idea, what is special about this particular person, what resonates with you, and what is it you're getting from that. It is not illegal, it is not unethical per se. You may get a report because people may know that person's your client or they've talked about it openly online or with their friends and family or so on, and somebody may not like that. What you need to do, though, is document a conversation with the client, soon to be former client, saying, hey, if we choose to be friends after therapy and go for coffee and talk about things, or, we can never be therapist client again. And if you're willing to agree to that, then we can explore what you think is friendship, um, and making sure that they are not thinking, hey, this could be a sexual relationship or some sort. sexual relationship with your client or former client is always wrong. Now, all the ethical rules have some time limit in them, 2 years, 3 years, 5 years. Ignore that. There is only one way to date your client, former client, is you terminate with them officially in writing. I am no longer your therapist after 30 days, blah, blah, blah. Here's some resources. I wish you well. And then there is a 30-year waiting period. And then after that, you can hold hands on rocking chairs on the deck. That's it. Um, Once a patient, never a partner. That's the motto from the Oregon Medical Board. I think it's an appropriate one. Every year we do have those clients that have those relationships, and almost exclusively you would lose your license. Um, I've had some variations on that, and I have had some dismissed where it was the allegation was it was sex with the patient, but it wasn't. It was an assault by the client on the therapist. So those things do happen, and you have to kind of just be aware. But when you're choosing to be friends with somebody after therapeutic relationship, I would think long and hard about it. And as a default, I would decline. That's just me. I tend to be risk adverse. And so when we have conversations, I try to identify that, at least saying, hey, I am risk averse. And if you're not, then let's talk about how this might look. If you're offering non-therapeutic services to your client, that's a problem, because now you're in a dual relationship. So I know a lot of people want to open up a yoga studio or a music place or a whole variety of things that are non-therapeutic. Although you could argue, hey, yoga is therapy, it has a therapeutic benefit. Um, I have yet to find it in yoga with Adrian, but I still look. I'm usually so angry when I'm doing it. It's not fun. No, I enjoy it. I enjoy hating it, is what I mean to say. Um, but if you're offering those, are you offering it to your clients? Because if your clients come to your yoga thing, now you've got a non-therapeutic relationship with your client and a therapeutic relationship, and that's the definition of a dual relationship. And so you got to be thinking, is this prohibited? And more importantly, is this a good idea? What if the client wants a refund and they attended all the yoga sessions for 20 weeks, and now they want a refund because you said something, a comment that they didn't like, and they didn't like what you said about it, and now they want a refund for everything. Well, they attended all the sessions, they got value for their money, and now you're having to barter or negotiate with your client. That's not a good look. And so be careful when you're doing these other services. People often ask too, should I keep my license or should I go do my coaching aside? The thing is, you can always do stuff like that with your license. So you could have a coaching practice, you could have a therapy practice. I wouldn't allow the clients to interact or interchange between those, but at the same time, you can have that. Um, excuse me. You just have to be careful with, are you, because if you can offer it under your license, you can do pretty much anything. If you have a license and you call it coaching, that's fine because your license allows you to do the things coaches do. The problem is if you're just a coach and no license, the question is, are you doing unlicensed practice at that point? How does that state or wherever you're doing it at define coaching? They don't. And so does it fall into one of the categories of practice of psychology, practice of licensed professional counseling, social work? Does it fall under those categories? And they're often very broadly defined, that you're using counseling techniques to help clients with their problems. Isn't that what a coach kind of does, especially if you were trained as a LPC? It's kind of laughable to say you're not using those skills in your coaching services. And so you invite that risk that the board could say, hey, we think you're doing therapy, and you don't have a license. So I'm going to transition to what ICE, if ICE shows up, and then we'll ask some questions before the next break. So there used to be these protected places, schools, libraries, hospitals, the Biden had put in that said, hey, these are protected places. We do not do ICE enforcement in these places. Trump, in his infinite wisdom, decided that that wasn't a good policy, mostly, I think, because it was Biden's policy, and now they are open. There are still some private places, and this is still being kind of sorted out. So be aware that they are pushing the envelope as hard as they can. Do they need a warrant to enter certain areas of your practice? Yes. They can come into the lobby as anybody could. But bottom line is, can they go back to the private areas? And the short answer is no. They need a warrant for that. They often have only an administrative warrant, which is not valid to enter private places. They need a judicial warrant signed by a judge. Now, that being said, if they come in, guns, masks, the whole works, like they've been doing, comply. So they can come into your office, but they can't access the private areas. So you may want to put a private or employee only to the door to your back office, or places you just don't want them entering. How effective that is, I haven't been involved in one of these yet. So we've had a number of cases where police will come and ask for things, and depending on whether it's a child abuse investigation or something else, we either give them the records or we don't. But they're usually not very forceful about those types of things. ICE is a different beast, and they have a lot of authority, and they're being challenged in courts, but in the meantime, they're out there doing these things. And so record the encounter if you can. Document anything that they took or anybody they took. Cooperate. And if they force their way into that back room, all you can do is I would step aside and say, I do not consent to your entry. And that's about the best you can do in terms of them coming to it. The other question is, do you document immigration status? Generally, I wouldn't, but if it's clinically relevant, that's the thing that's causing them the issues. It's kind of hard not to mention that. But bottom line is, putting it in the chart is not going to get them deported. ICE is using other methods for that. They did try early on to get access to some of it, but they were thwarted there. But bottom line is that generally the police are not going to be seeing what's in your chart, so that's not going to be the trigger. But it could come up in other places in terms of your document gets used in a divorce case, and one of the spouses decides to call ICE or whatever, but they're not going to do it because you documented it in the person's chart. They're going to do it because they know the person's there illegally or has visa issues, or they're being vindictive, and so that's usually what triggers those types of things. It will not be your chart. So let's talk about any questions we have before we take the next break.
All right, our attendees today are not shy of the questions, so I will run through as many as I can.
I found that to be true about them.
In regards to sticking with your role, I will often include other family members to support with the client's goals for the well-being of the client. Are you saying you cannot include family, then go back to individual with the client? It is clear that the client is still the client, and somebody followed up asking if you believe the parents should be signing collateral participation forms in these situations.
No, I mean, so I'll take the second one first. If parents are, you're meeting with the parents without the child present, you're not doing individual work with the parents. Everything is child focused. So you're meeting about the child, and so you can have conversations with them, you can give them resources, you can give them education, you can do a variety of things, but you're not, you find one of them has some childhood traumas that's interfering with their parenting style or whatever, you should not do individual work with that person. You should refer them out. If you invite family members in, what I want you to do would be to give them that document, the non-patient collateral document that says, hey, here are the ground rules. You're here to support John. And so they're there for support roles. And so they are not your clients. You're not doing therapy with that family. So you're not doing family therapy. You're doing individual work with family present. And they are given all the given documents saying, hey, you're not my client. What you tell me may go in the chart. You don't have access rights to the chart. And if you need a therapist, I can recommend one. Or you can do pure therapy, family therapy, and have everybody in the family as your client. And they would all sign intake forms. And so, but determine who your client is at the beginning and maintain that, because changing it and saying, oh, somebody else is a client now, if they're not a client, they should have, and they're in your office, they should have a document that says, hey, here's how this works.
It looks like someone followed up in the chat with how do you get collateral contracts when you are meeting virtually?
Email. You can email it to them. You can have it on your portal. You can have it any variety of ways, how they sign those documents. Your client, you send them a packet by email, or they, download it through the portal and sign in on things. Your portal should allow something like that somebody else needs to come in and access that. There'd be some access issues, I guess, giving them the password and all that sort of stuff. So it might just be that you would send it to the client and ask them to sign these and send it back to you. But they are important documents. It'd be like seeing a client without having informed consent documents signed. I still run into therapists who do not use informed consents because they just got out of the habit, or they never have used it from the beginning. The problem with not having informed consent is if something bad happens to the client, in normal circumstances, something bad happens to the client, they commit suicide. The family would have to show that you fell below the standard of care. You made a mistake, and that mistake was a significant contributing factor to the damages suffered by whoever's suing you. If you don't have informed consent, you're strictly liable. So even if you did nothing wrong, perfect treatment, and the client still ended up getting harmed somehow, just the nature of their disease. They assaulted somebody, they committed suicide, they did a variety of things, and there is nothing to say you fell below the standard of care. If you don't have the informed consent document signed by the client, says, hey, you might feel worse before you feel better, there are risks, there are benefits, that kind of information, you are strictly liable. They don't have to prove you fell below the standard of care, which is a huge thing. It's now just, did something bad happen to the client? You're responsible. That's how simple that case is. Normally, they'd have to bring in experts to say, hey, here's the standard of care. And that's what we argue about in those cases. And so informed consents are critical. Have them sign it. And the same with the non-client collateral form, it's important.
I had a few questions come in about a sliding fee scale. So somebody asked, I'd be curious how best to manage having a sliding fee, low cost spots, any ways to make ethical exceptions to standard financial policies, and a couple others had asked the same question as it relates to insurance.
Yeah, every year I get questions like this, and they have been told by somebody that you can't have a sliding fee scale. You can't charge different rates to different people. Completely untrue. Hospitals and nonprofits and some others have some regulations on what they can do like with stuff like that. But bottom line is, you as a private practitioner can have sliding fee scales. You can have a cash discount. So your normal rate is say 150 an hour, and somebody wants to pay cash, it's 125 an hour. If somebody is going through a hardship, have them document the hardship. Just have a single piece of paper that says hardship form, whatever, and have them document what the hardship is, how long they think it's going to last, and how much they can pay. And then you sign it, they sign it, and it should be valid for 3 months, 6 months, something like that. But it should have an effective date and it should have an end date. Very simple little contract, and you can do that. You come in, they bring you the copay that they agreed to, and you're fine. If they fall behind, the one thing that you have with clients is they want to see you. And so you can say in your informed consent documents, if you end up having accounts receivable with me, you owe me money, then I may pause treatment. I may terminate treatment. So I may pause or terminate treatment until the balance is paid. And then you do that. If they show up and they don't have the money that particular day and they're not in crisis, you reschedule. And so they'll get that message pretty quickly that, and therapists sometimes have a difficulty with that. And the first week of law school, they got rid of my heart. And so I have no sympathy. No. It's difficult having those conversations with clients, especially if they're under hard times. But bottom line is, if you have an agreement with them, you gotta enforce it.
And I had somebody ask how often they should have clients signed informed consent forms. Is it just on the outset of therapy, or should they update them yearly?
Um, After you change your informed consents, so they should sign it initially, and then anytime you go and make changes to it, I do a lot of document reviews for people who are either starting out or have had notes for or documents for a long time and just want to kind of get a review of it. And then, so we often change the language or add the language. For example, I'm a fan of using permissive language as much as possible in these things. So I may be required to report suspected child abuse. Not that I shall, because there's a lot of exceptions. And especially if you're a psychologist, shall is not the right word for it. So I would use may and those types of things. And so anytime you make a change to it, I would have everybody re-sign basically.
Okay, and then in the state of Oregon, when a 14-year-old presents for outpatient mental health services with the parent, is the minor required to sign their own consent of treatment, or can the parent provide consent on their behalf? Additionally, if the parent consents to treatment, is a separate release of information still required to communicate with parents, or is that only necessary when the minor independently consents to treatment under ORS 109675?
Well, let me give you the answer that when people ask me really hard questions that I give typically. Mr. Cooney is dead. He's no longer available to answer your questions. And so, um, now those are difficult questions, and we will get into the minor stuff here a little later this afternoon, and hopefully all those will be answered. If I don't answer that specific question, ask it again, and I'll be happy to address it.
And somebody wanted you to clarify if you can ask more about if it's okay to ask colleagues to write positive reviews.
I think it's perfectly fine. Counselors have a specific rule on asking clients to give reviews. Um, I'm not a fan of it necessarily. I'm not opposed to it, but especially when the client is still a client, there is a tendency often for them to want to please you as the therapist, and so they will, do those things if you ask them. And so I would generally refrain from asking a client to do that. But the ones that don't like you are just more than happy to, paper the internet with how bad you are. And so I think asking colleagues that know your work and know you as a therapist can and should be happy to say, I know this person, I refer clients to this person, they are a great therapist and a wonderful human, that kind of thing. So I think it's perfectly fine to ask colleagues for that. Colleagues can feel free to say yes, no, maybe I don't do that, whatever. Um, People often ask me for that. So yeah, it's an interesting dynamic. But you can have colleagues do that, and that bumps up your score. I wouldn't go and do fake ones where you just make a fake account and then start, giving yourself 5-star reviews. I think that's disingenuous and not fair.
Um, Next question is, can you also speak to what level of communication is appropriate via messaging platforms between sessions like MyChart or Simple Practice Chat?
My father said email and texting were the work of the devil. So that's my answer. um, I have cases where in 1 year of therapy, there was a stack of paper almost as tall as I was from emails, endless emails. And that's a problem. That's a serious problem. The client has a different view of what therapy is like than you do. So control that. I know people who still have policies that say, I don't email, I don't text, or the only way I text is if I'm going to, for appointment reminders. That's it. If you get a client that starts pushing that boundary, so one, establish your boundary up front. What is your email policy? What subjects can they email you about? It's not intended for urgent purposes. If you're in a crisis, call 988, 911, go to urgent care, those types of things. But bottom line is, what is your policy and are they following it? And typically your response to anything that is not appointment related or administrative would be, and I would have a little canned response in my text all ready to go that says, when this client texts me, I can say the following. Those are great subjects to talk about in therapy in our next session. And I would just leave it at that. And if the client continues to push that boundary, I would talk to them and note it in their chart that you had a conversation with them about this and that's not going to continue to happen. And if they continue, then you can consider terminating with 30 days notice. Um, but yeah, it can be a real problem. And some therapists have a very loose text and email policy. Whatever goes, whatever comes and goes is whatever comes and goes. I see people getting in trouble texting to clients, especially if the client is late. And starting to chastise the client in a text is usually not the way to go. Um, I would have a conversation with them if they're late all the time or certain things and document that in the chart. And so if you do need to terminate them, let's say they've missed um, 3 appointments this month. What's your informed consent say about missing sessions? Is there a limit? Or do you just have unlimited misses and you don't have any consequences? I would have some language in your informed consent that says, hey, if you miss more than 3 sessions in 60 days, I may consider pausing treatment because frankly, the client may not be ready for therapy. They may not have the right time. They may not have a variety of things. And so they just may not be ready for therapy at this time. And other people are often on your waiting list who would be willing to comply with all those things. And so use that policy and use that to kind of weed out clients that are not listening to your boundaries.
Do you want to take some more questions?
Sure, let's do a couple more.
Okay, I have, how and where should you document legal consults for your own protection?
I would have a separate notepad of some sort. You can use those, phone message logs you can get at Office Depot or some of these others, or just a separate piece of paper that says attorney-client privilege at the top. Do not destroy, do not copy, whatever, and then just take notes like you normally would. And then just store those in a red folder that says do not copy or, some way of having that if we need to use it in a board complaint, I often will tell the board, hey, yes, we did consult on this before they did these things. Here's what I told them. And, it's not a get out of jail free just because Cooney says, hey, you can do this. But the board does like people who consult and talk to others before they start doing things, whether it's an attorney or a colleague. Um, doesn't really matter. It's just that you're consulting.
And I had somebody write, I'm not clear as to what the problem is with writing letter regarding their dog being an emotional support animal. For example, they will be allowed to have their dog in the apartment where they live. That would be if I'm certain the dog is an emotional support animal.
There is a article written, actually a couple articles written by primarily Jeffrey Youngren, who's a psychologist, and he talks about the dual relationship nature of those letters. It's a little bit of a forensic side of things when you're doing these letters. What's the animal do for the client? Do I have enough information to say that the client has a disability and that this dog or cat or chicken or because service animals can be pretty much anything. Service animals, true service animals, can only be dogs or miniature ponies, I believe. But your your therapy role is being extended or shifted over to a more evaluative role. And really, the question is, are you comfortable with that? He's not saying you shouldn't do that, but I'm also saying you can do these letters, but you want to make sure you're doing your due diligence. There was a discipline a number of years ago where the person just didn't have enough information to say, hey, the dog does these things, and um, I've never seen them together, is basically what the problem was. So if you have information and it's good and you know what the standards are, you're not just guessing. What should I write in the letter? You should know what should go into those letters for housing. And so if you know those things, then that's perfectly fine. I'm going to rest my voice for a second. Let's come back in about 10 minutes. So let's get back to the seminar. I am going to be talking about the things that therapists do to get into trouble. And I'm having a little issue with my screen. So these are the things that tend to get people in trouble. And then my favorite, you get in trouble if you don't call me. Actually, I took this up to 11 because there's 11 things there, including don't call and not calling Paul. So 10 things that I often see people get into trouble with, things that I often consult with. And so let's just jump into it. Not disclosing pertinent information on credentialing forms. You have to have the position that it is disclose and explain. Do not rely on the idea that, hey, this question did not ask that directly. Or I can read it narrowly, and that's not what the question's asking. So my arrest at a protest or my DUI or whatever it is, I had something that was initially charged and then I did a diversion and it got dismissed. I don't have to explain, I don't have to do any of that. No, it still shows up. Even expunge stuff is what they require. And so read each question very broadly. On the LPC board, I did a case where I broke down the first question, and there were 21 questions in that first question. Have you ever been sanctioned, limited, investigated, disciplined in any employment, association, group? And each of these had, 3 or 4 sections to it. And so as you did your diagram, asking one question all the way through, then the other ones, and changing, each of those. There were 21 separate questions. And I just pointed out that's a little ridiculous. Maybe we should make it a little more simple. But they didn't. And now I don't get to see it because they went to the portal and I don't get to go into the portal, see what kind of questions they're asking. And so bottom line is if you're supervising anybody that's looking for licensure or has gone through a board complaint or have a variety of things, they should disclose and explain. Because if you don't, what happens is the board says, hey, we found out about it by doing a background check, which they do, and you didn't disclose it. So now we're going to investigate you. You admit you didn't disclose it because you didn't assume that it included that question, but it does. And we're going to sanction you by having a public document saying that you tried to obtain a license by misrepresentation or fraud. That's terrible language. It's not what happened, but that's the language of the statute. And so that's what they do. Don't minimize the facts. This is not a persuasive paper that you're submitting. You're submitting, hey, this is what I did. This is what the court did. This is where I stand today. Get the documents, get the police reports, get letters from your attorney if you had one, that kind of stuff. When I applied to be an attorney, I had several things that I had to disclose to the licensing board. I was the number 3 son, so the 2 older brothers pushed the envelopes enough so that I could get into all sorts of trouble. And so I had to actually write down on a piece of paper that I tried to, because it asked, hey, have you ever had police contact? Oh, crap. So I had to write down that, yes, I had police contact the night that we tried to light the Lake Oswego, the lake, on fire. It was frozen, so it wasn't going to blow up or anything. But it was a stupid thing for us to do. And I had to live with that. I also had to tell them, hey, I took beer off of a beer truck one day and then had to go apologize to the owner of the company and all that sort of stuff because my father was old school. So Embarrassing stuff, yes. I've been through both the bar licensure and licensure at the Spirit Mountain Gaming Commission. I was on there for a number of years. They do the full FBI background, all that sort of stuff. And so I had to do it on those too. And it's interesting to see your past come up like that. If I had just thought when I was 17 that someday trying to light the lake on fire might come back to haunt me, I won't do it. I did not, my 17-year-old brain did not think that way. Sparse charting. I know people have different views on charting. Some people have been trained less is more. If that's been your training, we need to talk. That is not, in my opinion, a good way to chart your encounters. Charting protects both you and the client. And so you have to remember that. It's not just the client, it's you as well. Documenting this stuff makes a difference. And it's important to write the things down. And too often, what I see as a chart note is just this running narrative from the client that this was a birthday present that they didn't like, and the parent should have known they didn't like it because they never wear green, and all these different things. Or they have a complex family dynamics, and it's just this narrative of this complex family dynamics, and that's it. That's not a note. There's nothing in there about what all this means to you as the therapist. It's fine to have that level of detail in there, but that is often the least important part of your note. What does all this stuff, this chaos in the client's life, mean to you in terms of diagnosis, in terms of treatment plan, in terms of what interventions might work, whether you need to refer them, whether you've met medical necessity, all those things come into it. And I've seen 35 chart notes on one piece of paper. That's not a chart. It's just not. And if you accept insurance, the number one thing you should remember from this seminar is get the documentation guidelines from each insurance company. They have behavioral health documentation guidelines and or audit criteria. If they'll share their audit criteria, great. Because you tell them, hey, I want to be compliant if you guys ever audit me. So send me the criteria that you're going to judge me on. If they want compliance, that's what they should do. But at the very least, there is a document that says, hey, behavioral health specialists, we need you to document this way. Start and stop times in the chart, not on a calendar. Total amount of time. Diagnostic criteria. What's going on where they meet this information or this diagnosis. And so make sure you're charting those types of things. So general notes on thought, sparse notes are bad for the therapist and the client. It does not help corroborate what you're saying. Let's say the client suicides and you don't have any good notes really about a risk assessment for that last session. And it's always the last session that becomes the detail. Hey, what's going on with this client? And so um, sparse notes are terrible for insurance audits. They are terrible for lawsuits, and they are terrible for board complaints. Those are where I see them. Now, they may be fine for what you use them for and just being able to know what's going on with the client. And but writing down that they were tearful again 35 times in a row doesn't really do much. Do not copy and paste. It's super tempting in a EHR. You can do it to a small extent, but I've reviewed a number of files recently where it is the exact same language, say for a suicide assessment. Client denies suicidal or homicidal information or intent, that kind of stuff. And it's not really a genuine, hey, are you, given what you've been through, it's not uncommon for people to feel like they don't want to be here anymore, or and approaching it in a more conversational way instead of here, fill out this little screening tool that they give you every single time. I have stopped doing that with a number of offices that I deal with from time to time. The short answer is I'm not going to fill out your form, because if you want to have a conversation about it, great. But this is not going to work, and I'm not going to spend every time that I come see you telling you whether I'm feeling sad or not, or that kind of stuff. So um, make sure that you have good content, who showed up, what does all this mean to you? What's your therapeutic impressions? What's your diagnosis? What's your rule out diagnosis? What's your differential diagnosis? What other things might be going on? Um, it should be no surprise to people. You do have to release your notes in most cases. You do have to release your notes in most cases. Therapists are the toughest people to get records out of. They have this policy. I've never sent my records before. I don't think I have to. I shouldn't. This might be harmful. I don't think parents should be able to access their kids' records. I don't think spouses should have that access. I don't think it's fine. You can have those thoughts, but if you get a request for records, you've got to figure out what your response is going to be within 30 days or ask for an extension. You do have to respond to subpoenas issued by attorneys. You do have to respond to subpoenas signed by attorneys. That's just the way it is. We have subpoena power. Every year I have people saying, oh, you don't have to respond to that. It's signed by an attorney. Real subpoenas have to be signed by judges. No, they can be signed by judges. Judges can use court orders. They can use subpoenas. They can do a whole variety of things. Motions to show cause, all that sort of stuff. But bottom line is, if you get something that is a subpoena, send it to our office. We review those for free, or your insurance company will pay us a small amount to guide you through that process. Absolutely. Do not respond to a subpoena without talking to an attorney, because there are a dozen different kinds: state, federal, criminal, civil, juvenile, administrative, you name it. It just goes on, and they all have slightly different rules. And so bottom line is, you should not know whether it's a valid subpoena or not. And they've gotten much better. When HIPAA first came in, boy, attorneys across the state just missed the mark time and time again. They were sending out subpoenas that were clearly not valid. They hadn't read any of that stuff. And so we were on a rampage for a while saying, hey, your subpoena is not valid. And if you want to piss off a lawyer who is in the middle of trial and trying to subpoena a witness, and you're telling them, hey, we're not going to comply, you get to see their personality uh, disorders come out. Your notes are your defense to an abandonment claim, or they're the notes that will sink you because you didn't give any notice. But if you give a client 30 days notice, you can terminate with any client anywhere, anytime with 30 days notice. You should not be kept trapped in therapy, even if they're in hospital because of a suicide attempt. You can say, hey, what we're doing isn't working because you're in the hospital yet again. And so we've talked about you needing a higher level of care, a different level of care, however you want to phrase it. And this is a good time. And once you go through DBT or whatever else, and you may want to come back, I'm here or not, you can make that decision. But bottom line is, you can transfer a client in that situation. You can transfer a client in any situation. And so I would go to the hospital if I could. I would have the conversation face to face if I could. Sometimes they don't allow that, but the client is in a protected setting. They have a team approach, and that team needs to know if they release them back into the wild, they're not coming to see you. And so give them the heads up and say, hey, let's figure out where this person should end up. And they have the resources to help with that. And so do that. Keep current on your notes. We've talked about the AI and all that sort of stuff. But if you fall behind, take action. Don't just try to pedal faster and doing the same thing you've been doing. Pause clients, catch up, talk to somebody. I used to have a great practice consultant, and they were very helpful with those types of things, making templates for notes and that kind of stuff. But if you're, more than 10, 20, 30 notes behind, and you're trying to recreate them, I would caution you to say that may not be the best course. You're wasting your time when you could be making notes now and going forward, keeping current, and then catching up as you can. But catching up, it means you're creating a false document. You don't remember that session that clearly unless you have some handwritten notes. And so creating notes just from memory, going, oh yeah, I remember we somewhere along the past we talked about this, so I'm going to write this down. That's grounds for all sorts of problems. So don't do that. In one case, we had a surgeon who used the copy and paste method, and this was quite a number of years ago. But when electronic records first started coming out, and he wrote in there that all extremities were normal, and this was a quadriplegic client. And something had gone wrong in the surgery. That was not what caused the quadriplegia. The client came in that way. And something adverse happened during the surgery, and they were being asked about their notes. And they played that slide of all extremities normal probably 100 times during the trial. Just, if you got this wrong, what else did you get wrong? You're not a very good surgeon, are you? You're not a very good doctor, are you? You didn't do this right. And they just kept playing it and playing it. It played up with the jury. Don't put legal consults in there. Document. So in lawsuits, this is how your record will be used. It's always the last note. If it's a suicide case, if it's a custody battle, what did they tell you about domestic violence or child abuse or all those types of things? Criminal cases, and hopefully it's not your criminal attorney that you're talking to, but in criminal cases, your client has an attorney, or in civil cases, that matter. If the client has an attorney and there might be a chance that you get called, you should talk to that attorney. I tried when I first joined up with OPA is making myself available for free. OPA doesn't pay me for this, nor does ORCA or anybody else. This is time I donate to the cause. I think you guys change lives for the better, and it's important. And so these are the things that you want to make sure that you're charting right. And if the client has an attorney, get a release, go talk to the attorney and say, hey, should I even be talking about the event? Because if it's not necessary to do that clinically, then I would avoid that if possible. If not, then you got to get into it and you got to take notes. But sometimes an attorney will say, yeah, if you can avoid talking about it, that's just another thing that somebody can cross-examine my client on, because you're paraphrasing as a therapist, you're paraphrasing what the client is telling you. And the lawyers are notorious for saying, oh, in your therapist note, you said the following things. Well, it's not true. That's what the therapist wrote down about what I may have said. And so good lawyers can deal with that type of stuff, but it's another thing for your client to be grilled upon. What they told you is different than what they said in other statements. Don't alter your notes. And by that, I don't mean, hey, don't go in and complete your notes and finish things that you may have left. But after about a week, there's no hard, fast rule, but after about a week, I'd say your note is about as complete as it's going to get, and you should sign it or finalize it or whatever you're going to do. And then if something else comes up, do a new note as an addendum to that particular note. It's got today's date, all that sort of stuff. You're not making alterations. But what happens is sometimes you go in, and this has happened a number of times, therapist gets sued for malpractice. They pull up the file because they're being asked to send the file to the attorney, and they're going through it. And if it's a paper file, they've got a pen in their hand, and they're, just filling in the gaps. It's correcting a misspelling, doing this. Oh, I do remember we talked about suicide that last setting, so I'm going to add a brief note there. Unbeknownst to them, there is another copy of the notes that are already out there. Somebody had them. And so then they get grilled on, hey, why did you make this change? Because the notes you sent us are different than the notes the client got when they asked for the records. And that is just death to any lawsuit. You lie, and we settle the case. We've had a number of those. And initially, especially if you initially deny making any changes or don't tell the attorney you made these changes, then that's a problem. The thing that I hate the most is like in a board complaint. I've talked to the client. Let's say we're prepping for an interview with the investigator. By the way, two investigators at the Board of Psychology and one's at the LPC board now, but they have the last name Vile. And I think that's just a lovely name for an investigator. And they're both actually really nice people. So they don't stand up to their name. But the thing that I hate is we prepare for the interview, we go in, I tell them, hey, at the end, the investigator is going to ask you, is there anything else you want to say to the board? And you say, great. And the answer is, I tell them the answer. The answer is no. If we're going to send anything or tell them anything new, we'll send it to them in an email after we have talked. But every year I get a client or two that answers a little bit differently. And they say, well, I haven't talked about this with Mr. Cooney, but here's some things I'd like to tell you. And there are things that will affect the case. And so I politely ask for a break. And I try to find someplace quiet so I can yell at my client and tell them to stop doing that and to go back in and answer the fact no. And we're going to, maybe send stuff later. But um, there's my board complaints. The board will always ask for your notes. They want a complete copy of your file. If it's disorganized, illegible, um, you know, that's a problem. And I've had several cases where that was an issue. One of them, the therapist was leaving town, to go care for their ill mother, and kind of put the stuff together. It was, not well organized. Some was written, some was typed, some was upside down or, shoved into an envelope. And, you can just imagine the person at the board opening up this package going, is this person competent? It shouldn't reflect on their competency, but they were sending stuff to the board, and had time allowed it should have been in a better format. Notes will corroborate what you say. The client says, hey, I don't want that treatment, and the allegation is you didn't give them any treatment or referrals to treatment. Having those in your chart makes a huge difference. Too often therapists hear, I don't want to do that from the client. I don't want to go to AA or SMART program or, because I don't believe in them, or I don't want to take medicines because I hate medicines, and so they don't write down the fact that they've given them the referral. Do both. Write down the fact you're giving the client a referral to AA, NA, any of the A's, whatever it is, and their response. And so, yeah. Termination letters, I'm a fan of them, especially with chronically ill clients. So if you're terminating for safety reasons, I think a termination letter is required. And so you would say on such and such a date, you came in and threatened my staff. You're no longer, I'm terminating with you immediately. You're no longer allowed in the office. If you come back, we will have you trespassed. Those types of letters I think are important to have. Or, hey, I haven't seen you in 60 days pursuant to my language in my informed consent that says, hey, if I haven't seen you in 60 days, I'm going to close your file and you can reapply to be a client again. That allows, having that language in there just makes it automatic that they're no longer your client. But sending a letter too can be helpful because they may have not remembered that or something else is going on. Document referrals. Insurance audits, I mean, your charting is the only roadmap that you have in insurance audits. You either met their criteria or you didn't. You either documented according to their behavioral health documentation guidelines. You may have to go look for it online, or you just may call them up and say, hey, I'm in behavioral health. I'm on your panel. What are your guidelines? Can you fax them to me or email them to me or talk to me over the phone and just tell me all of them? But typical start and top times, total times must be in the chart. If you're using 90837 and you're not documenting more than 52 minutes, you're doing something wrong. and you will get audited and they will ask for all that money back. And so make sure that your total time matches the code. Don't just get into this automatic, hey, I bill 90837 because they pay a little bit more. That may be true in some places, but they also have requirements for that sometimes. Some insurance companies require a pre-authorization for that particular code or for specific diagnostic codes, complex PTSD, major depression, those types of things. So know what the billing requirements are. If you're doing your own billing, God bless you, but you don't know what you don't know. And that's a danger in there. I've had arguments with people over the phone saying, well, 90837 is in their list of codes. I can use that. As if that's the only thing that it has to be on their list of usable codes. No, they had a whole bunch of other things in there. And certainly the older codes, 90806 and 808, had very specific requirements. The 808, the longer session, required you to document why you needed the longer session. And if you didn't document that in every chart, in every session, then they didn't give it to you. In some cases, we actually had to fight them to just down code to the next code down that didn't require that stuff, because what they did is said, hey, you don't meet the higher code, we're not giving you a dime. Well, I do qualify for the, the 3-4. So why not just, calculate the difference and I'll pay the difference. But they can go back many years, 2 years as a minimum. They can go back and see if there's any misrepresentation, which is not necessarily fraud. It's just that you weren't accurate in your charting. And if they find that misrepresentation, they can go back 6 years. And in some cases, even longer than that. The longest I've had go back was 8 years. And that was a multi-million-dollar payout. That case was simply a office who were choosing between two codes, two different buttons, upper code, lower code, upper code, lower code. And they were doing that diligently every time for this medical procedure. Very simple, no question about whether it was upper or lower. And they were doing that. And then one day they found out from another group that they were being overpaid on some of these codes. And they finally figured it out that whoever programmed the computer in that particular program made both buttons go to the upper code every time. So they were choosing, but the computer said, we don't care, it's upper code, upper code, upper code, upper code. So they were upcoding at least half of their charts. They self-reported, said, here's the scope of the problem, here's what we've done to fix it, tell us what you want. And it came back as, not only do you pay back the difference, but you pay back double that difference. And that's how the federal government works. When you get into their audits, it's horrible. And so same with the state of Oregon in many cases. They'll starting point is double what you illegally took. Medical necessity, if this is a phrase that is not familiar to you, you have an issue. We should talk. Medical necessity is the number one reason why people get audited or get requests for money back. Know what the definition is. There's the Medicare definition, and then private insurers can sometimes change that a little bit. The bottom line is you're not a paid friend. If the client has plateaued, you should be thinking, hey, medical necessity. Am I talking about the same stuff over and over again? And we're not really making any progress. What are we doing here? Do we slow down the frequency? Have we stopped meeting medical necessity? Is this just palliative care? And so this is whatever the diagnosis is and the interventions you're using, and to improve functioning. And so make sure if you don't understand it, go to Barbara Griswold. She has some videos on it. I think Melissa McCaffrey also has that. I know she has one, Charting in the Trump Era. I haven't, it's on my playlist to watch, but so be interesting to see what she's done. I've had some interactions with her just briefly. I like 99% of what she says in her stuff. Continuity of care, another reason why we document. you become incapacitated. Notes must be legible. You know, somebody's got to be able to pick up your file and go, hey, what's going on with this client? Have the diagnostic criteria in there. You know, if you've got an adjustment disorder for 10 years, there's a problem with your diagnosis. Use rule out language. I'm a fan of that. If you see some of the criteria, but not all of them, rule out borderline personality disorder. Use real diagnoses. If you think they have borderline personality disorder or bipolar or whatever it is that are, you know, problematic, I guess, diagnoses, use it. You know, your doctor's not going to say, I'm going to just write down you got the flu. Instead, you really got cancer and we got to treat cancer. So, you know, if they meet the criteria, talk to your client about it. Don't just hide it. I've seen that cause some problems. They wrote it in there and they never talked about it with their client. And the client asks for the chart, the client gets the chart 9 times out of 10. And so also have a professional will so you know who's going to take over your charts. Um, make sure that it is somebody who meets the criteria. Um, social workers had it in there that you could use a records management company. So at one point, I was helping out a client who couldn't find a custodian of records. And so I said, well, my former paralegal is running a scanning business and has a records storage um, facility, basically. Does she qualify for that? And the board couldn't tell me what was meant by their own definition, by their own language. And they'd never had anybody use that before. And so but make sure that typically you got to be a licensee. Sometimes you got to be specifically for that board. You got to be a psychologist or LPC or that kind of stuff. Or it can be any healthcare provider in some cases. But read the definition. Get used to reading, by the way, get used to reading rules and statutes. If you want to look up what the child abuse reporting statute says, go to ORS 419B.010, which is the reporting statute, or 419B.005 is the definition sections. You need both of those to read it, but be familiar, be comfortable looking things up yourself. I've read the child abuse statute reporting statute 20,000 times. You gotta be able to read that stuff. You gotta be able to go to the board's website and say, hey, where's the section on what I gotta keep in my records? How long do I keep my records? That kind of stuff. Have all that. So dual relationships causes problems. It is literally the number one thing that the board sanctions people for. Consider conservative values or boundaries. You can have liberal politics or conservative politics. It's entirely up to you, but have conservative boundaries. And just be able to say no from time to time. Helping the client is one thing, but sticking to your lane is important. We've talked about the non-therapeutic, seeing multiple family members individually and as a family is a problem. I know people are trained on that, but at the same time, when things go haywire, who was my client? Who could I talk to? Who could I disclose things to? It all makes a difference. And if you jumble that up and make that as muddy as possible, then trying to figure out who you can talk to and who you can do things with is problematic. And do you have a conflict? Stick to your role. Don't hire clients to work in your office. There's a number of cases where that has happened. I have had people get sanctioned, and I have also had people dismissed because of that. So it kind of depends on the facts. But if it's, you know, and they did one of them that I got dismissed, it was for therapeutic reasons. It was a small town. There were a lot of things that we could put together to say, hey, this made sense in this particular case. I'm not going to do this generally, but and the problem with hiring clients or their spouses or anybody else is what if they do a bad job? Not, you know, once you get past the, hey, we have a conflict here and this is not an appropriate role to have my client working in my office. If you can get past that, then just the practical sense is client can't pay for their services. Their husband is a landscape architect or landscaper of some sort. And in order to continue to see you, they want to barter for landscaping services, one landscape service for every session or something like that. The problem is, in that particular case, they killed a bunch of prize roses. They used herbicides in a sprayer before, and then they were spraying something else, and the herbicide residue got on everything and killed a bunch of stuff. Now you have a claim against your client or the client's spouse, and that doesn't work really well for the therapeutic relationship. We've talked about friendship afterwards. Denying access to records, don't. Just if the client sends you an authorization and they are not going to be suicidal or homicidal because of this, seeing those records, then send the records. In this day and age, it's a command for you to send the records. And the standard is if it's going to be physically harmful to them, they might commit suicide. It's reasonably likely significant harm would befall them. It's physical harm, not mental harm. So that's the standard for HIPAA, and that's the standard for Oregon now, basically. And so bottom line is send the records unless you can say they would be suicidal. You can get a subpoena or court order. There's health oversight agencies, so the licensing boards, Medicare, other places can get your records. Access to records, it's the policy of the state of Oregon that an individual has the right to review and access and review protected health information of the individual. You cannot have the policy that I don't turn my records over, period. So those that are still holding on to that, like it's the last vestige of humanity, then humanity's screwed because they can get your records. You only withhold records when there is, I'll use the LPC one, limit access to their records only when there is compelling evidence that such access would cause harm to the client. And so that's a looser standard than HIPAA. It's a little broader in terms of just general harm, but bottom line, that's an ethical standard. The HIPAA standard would trump that and say basically, well, unless it is to be physically harmful to the client, you got to turn the records over. You can't withhold records for non-payment. Those are specific. Psychologists have that records. Oregon law says, hey, the HIPAA holy trinity of treatment, treatment, payment, and healthcare operations. HIPAA is touted as a privacy law, but it is actually a free flow of information law first. So they say you don't need a consent of the client for healthcare or for treatment, payment, and healthcare operations. And I left out the word treatment there. So, and so you can share that information with other providers without the consent of the client. Your ethics allow that. For example, APA, trying to remember which one it is, 4.05 or whatever it is that you can share it without the consent of the client where it's allowed by law. Oregon allows it, HIPAA allows it, your ethics allow it. So you cannot have this, I don't turn over my records. I'll just read one section from here and then we'll take some questions and come back to this. But for too long, healthcare providers have slow walked their duty to provide patients their medical records out of a, oops, something pop up here, out of a sleepy bureaucratic inertia. We hope to shift the imposition of corrective actions and settlements under our right to access initiative will finally wake up healthcare providers to their obligations under the law. They have done more than 20 corrective actions, settlements, consent decrees, they call them, and they are going after solo practice to large hospital systems, doesn't matter. You have 30 days to respond and say, hey, I'm either sending them the records or I need another 30 days. The bottom line is you got to get the records to the people quickly. Too often people go, hey, do you want a summary instead of the chart? And then they don't docket anything on their calendar to say, hey, have you heard from the client about whether they want just a summary or their records? Today is day 30. You got to send the records today. Instead, they just forget, go about their business. All is good. I haven't heard from the client, therefore I don't have to send them anything. No, their initial request is still there. And so the clock has been ticking. And if you can't determine what they want, then you send everything. And that includes, your chart includes everything: emails, texts, session notes, intake documents, documents from other providers. If you're sending out your entire chart, you send out those other providers' records too. That is a change from what we used to tell people 10 years ago, because that's what Oregon law says. You don't send those records. But now that's been repealed. And what it is if it's in your file and they ask for the entire file, and treatment providers can ask for the entire file, attorneys can ask for the entire file. The minimum necessary often doesn't apply to these types of things, lawsuits and treatment. And so you typically will have to send everything. And so are your emails in a form that are easily transferable? Are your text messages? Often, you have trouble getting the text messages off your phone in order to send it. And so my advice is just get any 12-year-old out there that knows about this stuff and have them send all your stuff, because they know how to do it. So let's grab some questions if we have them, and
Yeah,
we'll
we
go from
sure
there.
do. First question up is divorced parents asking for records when they are in a custody dispute. Can we redact information about what child says about parents? In what instance can we redact?
You may not redact. That's an invitation for trouble, absolutely trouble. And so either parent, custodial or non-custodial, has equal access rights. So too often I hear it's just the non-custodial parent, so I don't have to send them anything. No, by law, 107-154, they have the right, equal access rights as the non-custodial, or the custodial parent and non-custodial equal access rights. And so either one can access the record. Rather than redacting things, I would chart maybe a little more vaguely. So, for example, if you know one parent wants to grill the kid about what's going on in session, and maybe using language like communication issues at mom's or dad's or certain things, I'm okay with that because it's not a reportable event. But if it's a mandatory reportable event, then I would use detailed language, I would use specific language, I would use quotes, that kind of stuff. But you cannot redact when somebody's asking for the record, especially if it's a subpoena. You cannot redact for that. And for the most part, whatever the authorization says, the release says, is what you send. And so they will check all these boxes. You can make your life easier by having a release form that has a lot of categories on it. So you can have, would you prefer a summary? Do you want session notes? Do you want billing? Do you want evaluations? Do you want emails? Do you want, you know, and if they only check, hey, I only want a summary, or I only want session notes or certain things, you have reduced your work considerably. And so I would consider that.
Next question is what is the difference between responding to a subpoena versus releasing the record?
You can respond to the subpoena. For example, I often respond to it saying, hey, you didn't provide certain documents you're required to provide when you serve a subpoena. And so I can respond, I can say, hey, can we get a Tuesday testimony time, morning preferred, or something like that? Can I testify remotely? We'll often ask for those types of things. So responding is one thing. And if you think there's problems with the subpoena and they've asked you to show up at the courthouse and there's not time to see if we can get it quashed, then what you do is you show up and say, I'm not sure. I've been subpoenaed and I don't know if I can release the records. I'll do whatever the court orders me to do. And if the court says you are hereby ordered to release the records and testify, you are protected. And so not turning over your records in response to a subpoena um, is never a good idea. So responding usually means you either show up and testify or you're sending records. Now, be aware that the client has had an opportunity and their attorney has had an opportunity to object to that subpoena. They are required to receive notice that this person is subpoenaing the records, and they're given 14 days to express their dismay. And if they do, then they have to work it out. And if they don't work it out, the subpoena cannot be issued. So be aware that your client has already given permission for this process to go through, and the subpoena is, um, I wouldn't say supported by your client, but certainly your client has not objected if you're getting the subpoena. And since it's the client's information and they control it, you really shouldn't have an independent grounds for not sending things unless you want to talk to the attorney, the client's attorney, and say, hey, I'm concerned because I have notes about something that might be embarrassing to the client or might affect their case or something. And so you have a conversation with that attorney, and then they will either get a protective order or do something more specific. So you can have conversations, but you don't get to make the decision. I don't think my notes are relevant. I don't think this is useful. I think this is harmful to my client. I think it's a subpoena. Subpoenas don't care what you think. So um, go from there.
This person works for an organization that requires the use of templates. They do have flexibility to add or subtract certain aspects for best practice. Can you speak to other things to be mindful of when using a template? We don't copy and paste, however, there are some things from the template that carry over and can look the same for each visit.
Yeah. Yeah, that's the pull down menus typically and that's kind of where I have some issues with some programs. And it's not across the board. It's not every program. It's not everything in the program, but some of the pull down menus limit you more than they should. And so you pick from one of four things maybe, or whatever it is, and that's fine, but it may not exactly fit. If there is an area where you can do, free form typing, then great. You can get around those problems, and most of them have that. But initially, when a lot of the programs came out, it was they were not great programs. And so make sure one, you're comfortable with the pull down menu options. See even if you can get them changed or if they're editable. Um, and that could make it a little bit better. But yeah, these are problems that you see in these notes that are generated, and you'll see it the same thing with AI. The notes generated often look similar. And so, when you read them as somebody who is, very comfortable reading chart notes, it comes across, it's kind of like when you see an AI picture and you can't really tell why you think it's an AI picture, but it's just a little too lovely or a little too whatever. They're putting up this avatar or whatever it is. Um, you know it when you see it. And, it will be used against you to some degree. But if it's a pull down menu, the attorney representing you in that case would be able to go in and show, here are the options, and this is the best of the four. And then they also wrote stuff down here, and so we can get around those things, but they do present kind of unusual grounds for lawsuits sometimes.
Next question. If you take handwritten notes during a session and then use those notes to complete your progress note, do you need to keep the handwritten notes or can you delete or shred them?
You can shred them if that is your policy. Now, I will say one caveat. I had a case once, um, made the media, all this sort of stuff. It was years ago. Client came in. My client was a therapist who had seen the child, and there was some question about whether child abuse was reported or not, and the statute of limitations, and all these different things. My client was very nervous about her notes and decided that she was going to retype them all. And unfortunately, the problem is if you have handwritten notes, is the what you're putting in the computer a verbatim, literally chicken scratch for chicken scratch, word for word, abbreviation for abbreviation, this and only this from this piece of paper, or was it filled in? And they spent a day and a half grilling my client about those policies. Well, you say this in this particular note here. What do you recall about the handwritten note that you shredded? And they said that every time. you shredded, you destroyed, you forever, denied us access to those records, as if they were the holy grail of this case, and they weren't. But yeah, it's problematic. I think it's perfectly fine. My policy is I take handwritten notes and I transcribe them into the computer. I no longer have a need for those, and so those handwritten notes get shredded. Perfectly fine.
Can you speak to the need to justify the need for 90837? If you did the time 53 plus and there is no requirement for pre-authorization, is there legal reason they can limit our usage? Can they say that it's not necessary to use 90837 for a certain diagnosis?
Yes, they can. Um, and that's one of those things that just go back and forth. More often, though, there is some requirement for that particular code. It's not just the time, and it's not just whether there's a pre-authorization. Like in the old code, they used to require, hey, you justify why you need this, and it's not. I can see the client less frequently. That was not allowed. It was the client has a physical disability and getting around in the office slows down the time, and so, or they have speech problems or cognitive problems, and that slows down the amount of work that we can get done in that. Um, Insurance has all sorts of issues, um, but you need to know what they're requiring. And if you use 90837 exclusively in the past, that has gotten people audits. Doesn't mean that they had to pay on those things, but it does mean that you really need to know what the billing side of things is. And if you have a billing service, that's what you pay them for, is to go through some of these things and try to find out, hey, what can we do here? What do we need for this particular code? Um, Make sure that if they're choosing what code you're using, then make sure that they take responsibility for that decision. Otherwise, you're responsible to tell them, hey, it's a 3.4 or 3.7 or 4.7 or whatever it is, depending on how many people are there. But bottom line, you're responsible for it.
If you don't take bill or work with insurance, is there any audit risk, like if these clients are submitting for their own reimbursement?
It's an interesting dynamic because you don't have any contractual agreement with the insurance company. And so it's just you have an agreement with your client. They would typically take a super bill, send it in to the insurance company. And in the past, the insurance company has been very hands off that process, but they have been becoming more and more active, I guess, in asking for session notes, and asking for certain things. Now, they can't deny it because you don't use their lingo or, certain things that their documentation requires, but they could deny the client reimbursement, but they can't audit you. They can ask for information. You can get the client's permission if they want it or not. It's entirely up to the client. But the client needs to know, hey, if we don't send the records, they could deny this particular claim and they wouldn't pay you the money. Um, yeah, it's working with insurance is a thankless job. It takes a lot of time. And so think about whether or not using a billing service makes sense for your practice. It can really take away a lot of the stress. So,
Still looking for a couple more questions?
yeah, let's do one more and then we'll take a quick break.
Okay, I had somebody ask if it was possible to speak about the release of a forensic mental health evaluation with the release of information from the evaluee. They contact hiring attorney first to see if they need to advise their client how this document may expose them.
Yeah, I mean, typically the person being evaluated is not your client. It's the attorney or the agency or that kind of stuff. Your informed consent document should state whether the evaluee gets a copy from you or they get a copy from the attorney or the agency. I'm a fan of having them get it from the agency or the attorney, because the attorney can be in a better position to know whether it's the client is doing it for good reasons or ill. And so we'll go from there. But yeah. All right, let's take a quick let's do a 5 minute break. I've got a lot of stuff to cover. And if I don't cover it all, you can get the PowerPoint and see the rest of my amazing things for you to talk about. Um, yeah, let's take a quick break. All right, why are we I love some of these comments. Let's get started again. And let me get back to my shared document here. So we've talked about the HIPAA grounds for denial. We'll go through those. If your client dies, there is a list of people who stand in the shoes of your client. And so whoever can be found with reasonable effort that's highest on this list. So typically a guardian or a spouse, majority of the adult children, either parent, majority of the adult siblings, any relative, adult relative, or a friend. So if your client passes, commits suicide, however it happens, family may reach out to you. And, if you know whether they have a spouse and it's somebody else contacting you, you can ask them to contact the spouse and contact you. But bottom line is, they can ask for records, they can talk to you, they can do all the things the client could do. And so it allows you to have the conversation. You do not want to become their therapist, obviously, so you would refer them out, but you can have a conversation, basically immediately after the death if somebody reaches out or you want to reach out. Some clients, you might want to go to the funeral. That's perfectly fine. I think it's a human thing to do. Um, I wouldn't, be the one giving the eulogy necessarily and saying, he was my client and on and on and on. But being there and sharing in that experience, I think is important. You'll get a sense too whether the family is blaming you if it's a suicide case, and so you can kind of shut those conversations down pretty quickly, and just say, hey, I think our conversation's over, or you can answer their questions. Coroner's office can get your records. You have me to thank for that because for years they were not able to get your records. And I got a little pissy at them one day and said, hey, this is the 15th time I've had to write this letter. You guys don't have, under the statute, the right to access psychologist records. So either stop asking or change the statute. They changed the statute. So now you have to send your records when the medical examiner asks. Subpoenas. Do not ignore them. Oh, I forgot that was in it. BAA. Attorneys can sign subpoenas. They're valid. If you're properly served, you got to show up. Talk to us, and we can talk about alternatives and various things. But bottom line is, you got a plan to show up. The witness fee is $30, so make sure in your informed consent that you have part of your fee agreement that if you were involved in litigation, I charge for the following services: reviewing records, travel time, testimony time, parking fees, consulting with attorneys, everything. And it should be your normal hourly rate that you would charge a client for an hour in your office. You're being paid for your time away from the office, not your opinion. And so you're a fact witness, you're a professional fact witness in most cases, which means, what did you do in therapy? What did you see? What did you hear? What do you know? Not, hey, let's take all this stuff and then formulate some new opinion about it and tell us the prognosis and all these different things and why people react these ways, and being an expert witness for somebody. You're typically not, you're typically a fact witness, and you just talk about what you saw in treatment. Now, the key to testifying, if you haven't testified before, it's a surreal experience. It tends to be far hotter or colder in the courtroom than you would ever imagine. You have to go through metal detectors just like the airport, so dress accordingly. Dress in layers so you can take layers on and put them off. Bring your file with you. Always bring your file with you, your complete file. And always testify with the source of your information first. Otherwise, you're stating things as a fact. If you say, the kids tell me dad yells and throws the phone and punches the wall and does these things. If you state it just like that, you've stated your opinion that that's a fact, that dad does these things. Instead, if you say the children tell me the following things, and if true, I'd be concerned about dad's ability to manage his anger or those types of things, that's fine. But always state the source of your information so you're not coming across as saying, hey, everything the client told me is 100% true. It often isn't. I represent really smart people, and they often, I wouldn't say often, but sometimes don't tell me the entire truth. And so that's just the way things are, and you have to assume that not everything that the client is telling you is 100% true. And you're never going to know whether it is or not because you're not a forensic evaluator, you're not an investigator, you're just there to work with what they tell you. That's the nature of therapy. Here's what you can charge for your fee for sending records. 30 pages for the first 10, 50 cents for pages 11 through 50, and 25 cents a page after that. You cannot charge anything you want. You cannot charge time for trying to find the file in your office. You cannot, if it's a particularly large file, take it over to a copy place. You can do that if they sign a BAA. If they sign that, then you can have them make copies. They give you an invoice. You send the invoice along with the file to the attorney or whoever's asking for it, and you're good. Doing this on your own introduces potential for mistakes. I've had a number of clients who describe themselves as photocopier challenged. One case where they were sending out a redacted version because the protective order said this side only gets some of the records, and so they were redacted, and a version just for me where I could get everything. And lo and behold, when the document came to my office, I'm wondering, why are all these redactions in here? They had sent the wrong file to the wrong place. So they sent the other side, who should not have gotten any of that, the full file. That created all sorts of problems. And for me as well. So um, every now and then I get something from the other side on a case. When I used to do the more complex litigations, the malpractices and all these sort of things, you would get every now and then you would get something on the other side, which was their confidential memo about the case. And I'd start, you reading an email, and so you open up the email and you start reading, and suddenly you realize about 3 sentences in, I should not be reading this. And yet the urge is so strong. Oh, I want to know what they see their case as. I want to know their strategies. I want to know. I was raised well by an attorney father who practiced for 60 years. And he taught me, well, you do not do those things. You immediately tell the other side and you send it off and shred anything that you get. Um, Workers' compensation is a different rate. Retained for 7 years. Here's all the things that the board says needs to be in your charts. So I'll go through the social workers and psychologists. Here are the things that they require you to have in your chart. This is what they consider a chart, so to speak. And so if you have them, you want to maintain these for 7 years. LPCs, similar types of things. Keep them in a secure place, all that sort of stuff. You are not the guardian necessarily, but you do have to take reasonable steps to keep them secure and private. Diagnostic malpractice is one of the 10 things that gets people in trouble. Adjustment disorder should not be used for a 10-year client. Maybe there's something else going on that you can figure that out, but if it doesn't last longer than 6 months after the stressor is relieved, then consider some other. I know people use that as a placeholder for insurance purposes. Typically it's, hey, until we figure things out, we're going to use adjustment disorder. It's kind of a catch-all thing, but bottom line is you need to be good at what you do, and diagnosing people is one of those things. It does carry some labels, it does carry some stigma at times, and so you want to make sure you're doing things well. The other thing that can be a problem sometimes is with the transition letters for gender dysphoria. Somebody wants to go through the surgery and they're asking for the letter for the surgeon. Make sure you're doing your due diligence. That is not a, emotional support animal letter. This is not one session and you're done kind of thing. There've been two lawsuits in Oregon, both in the multi-million dollars. One of them was at least 10 million, and it was transition regret. We see it in regular plastic surgery cases. People have an idea of what they're going to look like before, the surgery, and then afterwards, oftentimes you don't look anything like you expected just after a surgery. But others in the transition world where they're getting the surgeries, um, they often have very complex histories, complex trauma histories. And so you've got to go through and do your due diligence and making sure that you're kind of sorting things out, because what happens is they sue everybody involved in that process. And these are rare. These are like less than 1% of the time these things are coming out, but it does exist. And so your risk is not zero if you're doing these letters. And so shadow with somebody who does these on a regular basis. Make sure this is not your first time without having somebody review it and go over it with you. Pay for that service, but make sure that you're doing good diagnoses first and then evaluating other things that might be going on in their lives and whether that makes them a good surgical candidate. Not following the insurance documentation guidelines, we've talked about that, but they can seek money back. Those are horrible cases to work on because there's a lot of money at stake. And I had to tell that one guy who had the two buttons, that was pushing one or the other, you're going to have to pay back several $1 million. And he was just getting ready to retire. And he was like, crap, what now? Divorcing parents. We'll talk more about minors, but both parents have equal access rights to your information. You can control who has more access in terms of coming to session, that kind of stuff. One of them is disruptive. You can set boundaries. But bottom line, both parents have the right to access the information and to ask you questions and to receive a copy of the chart. When the kid turns 14, that makes a difference. And so we'll talk in detail about that. You cannot restrict your involvement in legal proceedings. You can have language in there saying, hey, I don't think it's a good idea to involve me as your therapist in your legal proceedings. It's not intended for that purpose. Great, I see that a lot. Bottom line is it's not enforceable. If I issue you a subpoena, you got to show up. Your contract with your client doesn't change the fact that I've subpoenaed you and served you validly. Don't make your testimony fee $1,000. Don't make it $500. Don't make it, your normal hourly rate is the easiest way to defend it, saying, hey, it's not asking you to go out and dig ditches. That's hard work. I'd want to be paid a lot of money for that. I don't dig ditches anymore. I used to. But you want to make sure that it's just consistent. It's not an excessive fee. And it should have language that whoever calls you as a witness, regardless of whoever calls you, your client will pay you for that service. Practicing across state lines. Bottom line is your client needs to be physically present in a state where you can legally render services. So if they're in California and you're a psychologist, there is a statute that says, hey, if you're licensed in another state, you can see somebody physically located in California for up to 30 sessions in a year. They are not consecutive days or anything like that. It's just any 30 sessions. You don't need a fee and you don't need to register. It's a great thing. Every state should have that, but they don't. Washington has a temporary license up there for psychologists. I think it's good for 6 months, and I think it costs a couple $100. The thing in California is not open to other therapists other than psychologists. Why that is, I don't know. But they should get their association to say, hey, us too. Have something in your informed consent. Typically, you have a telehealth informed consent because the risks for telehealth are slightly different than for inpatient or in-person, inpatient. the technology might be bad. They can't see nonverbal cues as well. They might have difficulty hearing or seeing. Um, whole variety of things come up. And so you would have an informed consent. And it should say in there specifically, client agrees to tell me if they are not in Oregon before the session. We may have to reschedule or cancel the session. If it's an emergency and your client is traveling out of state and they call and say, hey, I'm really struggling today and I need to talk to you, have a conversation. But when that's over, then go back to, hey, you can't call me unless you're in the state. Find them some local resources, and that'll be fine. And most states don't have a problem if you're the one traveling. So Oregon says, as long as it's legal in Kentucky, and let's say you're staying in Kentucky and you want to see a Oregon client, perfectly fine. Oregon will say, we don't have a dog in that fight. It's not our issue. You can be anywhere on the planet and you can see clients that are Oregon-based clients, Oregon physically located at the time. I think if you start to live in another state, that might change a little bit, but I don't know of any guideline that says it's 6 months or a year or whatever it is. But at some point, if you're living in that state permanently, you should probably really consider getting licensed in that state. Most jurisdictions, if the client is, say, in Idaho and you don't have a license in Idaho and the client files a board complaint, Oregon could send it over to Idaho and Idaho could say, hey, you don't have a license here, you're practicing without a license. Most states have a crime that is that statute. And so you have committed a criminal act by seeing a patient without a license. So I don't do that side of things in terms of criminal jurisdictions, but it's certainly within their purview. And for example, Oregon has the licensing boards actually take over the unlicensed practice stuff. Typically, it's the Board of Psychology, but others can do it too. And then they do a civil penalty or a civil fine or, hey, stop doing that, cease and desist. So that's typically not criminal. I'm going to skip a couple of these. Check out the other states. So if your client is going back for school, it doesn't matter that they're there just temporarily or anything else, or they have a residence in Oregon. None of that matters. It's where they're physically located at the time. And so find out if states where they're at have a limited license or a special permit or some sort of reciprocity. We're getting closer to SIPAC. They have 43 states now, and I know it was up for Oregon to do something, and I just didn't follow it closely enough, so I'm not sure, but it didn't pass Oregon. But that's what's coming, and typically SIPAC would allow you to be seen in other states. Social worker has a compact. They're in 7 states, and so they're a little less. And the multi-state compact for counseling, they only have 2 states so far, but I think 30 something are trying to consider implementing this. And so pay attention to that. For Oregon counselors, it's ORCA. They have a lobbying component, COPACT, and so they often have that information about these legislative things that are going around the states. Termination and abandonment. I think this is the #1 fear of many therapists. I don't want to abandon my client. I don't want to abandon my client. I've been doing this for 33 years and I've never had a true abandonment case. It's alleged a lot. You abandoned me like my mother did. You abandoned me like everybody else has, and that sort of stuff. That is not abandonment. It is clinically, but legally, you'd have to come into the client, a long-term client, typically, and say, I don't like you. I'm not going to continue to see you, and I'm not going to give you any referrals. Get out of my office. That's abandonment. It never happens. Now, sometimes therapists will terminate abruptly. And that's usually where you're getting closer and closer to an abandonment case, because the only reason to terminate abruptly is if the client threatens you or your staff. Otherwise, you work through whatever you're doing and you give them traditionally 30 days, and then you can transition. And so make sure that you're not doing abrupt terminations. Just because it's no longer a good fit is not a reason to abandon, quote, terminate with the client abruptly. You should do it with, hey, this may not be a good fit. I'm available for the next 30 days if you want somebody to talk to. Here are some resources, and so you might want to talk to these people, but I'm available for the next 30 days. They can avail themselves of that or not, entirely up to the patient. But that offer protects you from that abandonment claim. That's your defense. We discussed higher level of care or a different level of care, or my client came in and threatened me, or, here's all the things we talked about. They needed DBT and we're just waiting for the opening, and, that kind of stuff. And so document your termination strategy. That is your defense. And if it's not in the chart, it didn't happen. You chart important things, and termination or the future involvement with this client is an important thing. If the client harasses you after termination, I get that call easily a couple times a month, and it's fact dependent. So why did they terminate, or why are you no longer seeing this client? Why are they upset with you? Sometimes it's just irrational, and they've got that you abandoned me and you did harm and all these different things. It can be particularly problematic if in your discussions with the client that you're the one person that is the stable connection in their life, and you repeat that over and over again and that kind of stuff. That can be potentially harmful because clients often do things to sabotage that, and they will give you gifts, or they will push boundaries, or they will do things that they know they shouldn't. And now you're having to terminate with them, and you've broken that promise. You're just like everybody else. So don't put yourself in that position. Don't use that language. It's been a problem in quite a number of cases. Not reporting suspected abuse is a problem. Too often what happens is people think, well, I don't know the name of the perpetrator, or I don't know their address, or I don't know their phone number, or they've left the state, or that's the wrong path. We'll talk about child abuse reporting here in a second. Bottom line is, if you're on the list, you have reasonable cause to believe abuse has occurred. It's just a very low standard, and you've had contact with the child, then you're on a mandatory reporting claim, and you report what you know. That's it. Don't go down the path of I don't know, and maybe do I have to go find this stuff, or do I not find this stuff, and I can't report it because I don't know all this stuff. No, you report what you know. You've done your due diligence, you've done your duty. Congratulations, you're not going to be called up for not reporting child abuse by your licensing board. If you're using the word abuse in your chart, pause, put the pen down, or turn off the computer and think, why have I not reported this abuse? Abuse is a legal term. It's a term of art that says, hey, abuse means as it's defined by statute. So if you're using the word abuse, switch to what behavior are you talking about? Throwing the phone, yelling, hitting, those types of things. Some of those are not abuse, others might be. And so if it's truly abuse, then use that word, and your next note should be report. So minors, age of majority 18, or if you're married, then you're automatically an adult. In Oregon, age of consent for birth control is any age. Age of consent for mental health or medical is 15. For mental health, it's 14. It's for outpatient stuff. And there is a thing, if the child comes in wanting to see a child as in 14 or older, and they want to be seen without their parents, they can, but at some point before the end of treatment, the parents shall be involved. It's not defined what involvement means, Whether that's just notifying them that, hey, little Johnny's in treatment with me, or does that mean, hey, you know, you can now have summaries and that kind of stuff. We'll talk more about how that works here in a second. Non-custodial parents' right to access. They have equal access rights to provide, to consult with any person who provides care, and they can get records. And so stop thinking custodial, non-custodial really makes a big difference. It doesn't. There's also a statute that says the consent of one parent is fine. In fact, it's so fine you have immunity if you only get the consent of one parent. Now, I've dealt with that statute with the licensing board years ago. Non-custodial parent was asked to help improve the relationship with his 13-year-old daughter. So they started meeting and having these sessions together. Custodial parent was not notified. Custodial parent eventually found out, of course, and was livid. You can't do that, all this sort of stuff. And the board had this belief that only custodial parents can consent to treatment. It's not true. That's part of their divorce decree. Typically, it will have you know, they can consent to routine, non-urgent care. Both can do urgent care, but typically one is picked. But the statute, not this one here, but it says, even if it's contrary to the divorce decree, the consent of one parent is fine. And it's so fine you cannot be sued. Now, I sent that off to the board because they wanted to try to sanction my guy and say, hey, non-custodial parents can't do this. So I sent them that statute and said, hey, this is what I think. And it was actually kind of fun because they sent out an email that was not intended for me. And since this was not a lawsuit, I had no obligation to stop reading that email. And so, but it basically said from the investigator to the rest of the boards, Cooney keeps saying this statute is everything, and it just seems like if he just keeps repeating it, it's going to become true. And so I had to respond, and so I just said, hey, it is true, it is immunity. And in fact, the administrative law judge, when we eventually did go to a hearing, agreed with me and said, I think not only does it mean you can't get sued, it means the board can't investigate you. And I said, I didn't ask for that because I didn't reasonably think that was how far I could stretch that statute, but I agree with your analysis, Judge. You're spot on. And this is the 109672 is the consent of one parent. And so I think it's a good idea to get the divorce decree, parenting plan, whatever, for divorced clients. So you can see who really does have the ability to consent. But this is your backup statute that says, hey, you can get either person's consent. But it'd be helpful to know, do they have joint custody? Because joint custody means they both have to agree to change the status quo. So before treatment, the status quo is no treatment. So in order to put little Johnny in treatment in a joint custody case, not just shared, they share 50-50. This is a document says they have joint custody, specific meaning. In that situation, they both have to agree to implement treatment. And then later, when the status quo is treatment, they would both have to agree to stop treatment. And so bottom line is, and there was a case, they took a psychologist to try to sanction that. And the court said basically the boards are given deference in how they interpret their own rules, but they are given no deference in interpreting what joint custody means and some other things in other proceedings. And so that's part of the problem with licensing board complaints is they can interpret their own rules to mean pretty much whatever they want. They can't be arbitrary and capricious about it, but they can say black means gray, gray means black. They can choose what language they think is harmful or those types of things. That's why it's so hard to win sometimes at hearing with these licensing boards. They are given great discretion. And as long as they're not abusing that discretion, they can say, hey, we think this is harmful. So parents can consent, minors 14 years and older can consent. Grandparents, if you have the relative caregiver affidavit, which is a special form that says, hey, we can't get a hold of the parents, or anyway, it explains a lot of things if you have somebody who is not the parent. And DHS if the kid is a ward of the state. This is the relatively, I am having trouble speaking today. Relative caregiver affidavit just talks about things. There's actually a form online, but if you have a situation where the biological parents aren't available, you can use this. Now, if the child is brought in, regardless of their age, by their parents, and the parents want to sign the agreements or the intake documents, that's fine. Perfectly okay. 14-year-old does not necessarily have to sign informed consent documents. They can if you want them to. It's a valid contract that they would agree to, and so many places do have them sign, just so they know what's expected of them and what's expected of you. But it's a judgment call. It is not required, but you may. And 14-year-olds do have a say in who accesses their records. The way it works in Oregon is both parent and child have kind of a bundle of rights. And parents are the legal guardians of their children, and they must take care of them by law. And so they have the right to access records under Oregon statutes for their treatment of their children. But the 14-year-old comes in with a bundle of rights too, saying, hey, I'm almost an adult. And for the purposes of this particular little area in my life, I am treated as an adult. And therefore, I have a say. Now, when they clash, the question is, well, which one wins? And the short answer is, I don't know. And it used to be that you were on the default path to sending records to the parents. They changed that statute. And this is the first part of that statute. The first part of the statute says, now mental health providers shall disclose if the client becomes at risk for suicide, and it might help with safety planning and these types of things. And so you have to tell the parents. You may disclose to other people, school, primary care doctors, other places who may, help the minor in their struggles. And so bottom line is now you have to tell the parents if the child is suicidal. It's a big change from the past. I just did a seminar with DHS and kind of went through a bunch of that stuff. And there were a couple of cases recently in Oregon where the parents were not notified. And there were board complaints and lawsuits and various things. And so I think that's part of the factor here is changing that. And so be aware that if you haven't notified parents of suicidal issues with your client, your minor client, you have to tell them. Now, here's the other part of the statute that brings you more into tune with things is you're not required to turn over records in certain circumstances. And the number one reason that you would use is it is not in the minor's best interest to disclose the information to that individual. Best interest is the standard that they use in custody cases. Best interest of the child. Which parent is, in the best interest of the child, which should they live with, that kind of thing. And so now the therapist is given a voice to say, hey, I don't think that's a good idea to send these records to this particular client or to this particular parent. And you can do that. You can choose not to send those records. You may very well get a board complaint because you're telling a parent you can't access your kid's records. Those are fighting words. So we're going to run out of time here shortly, but child abuse reporting, it's different in Oregon than it is other places. And the way it works in Oregon is you need three things to come together. You have to be on the list. If you're a licensee, you're on the list. If you're an associate, you're not technically on the list because it doesn't include associates and interns and various other things. And so it's always been a question, and I have forever told the board, update this. Just make associates and interns. For physicians, they do it. They do for residents and interns. So they include that. And so by definition, the legislature knew how to insert that into the statute. They didn't, and therefore you can't read it into the statute to say associates must I still think associates must report. It's just a little weird thing in the law. But three things have to come together. You have to be on the list. If you're a licensee, you're on the list. You have to have reasonable cause to believe that abuse may have occurred. And that is a low standard. That is not beyond a reasonable doubt criminal standard. Preponderance of the evidence, just tipping the scales like in a civil case. This is way down here saying, hey, it's more than mere suspicion. Somebody should look at this. I'm concerned. That's the level. And if you have that, everything has clicked and you're on the way to reporting unless you're a psychologist, clergy, attorney, or psychiatrist. We lucky people have discretion. We are not required to report if we learn of the abuse in a privileged setting, i.e. in the office talking to a client. And so they are given discretion and everybody else is a mandated reporter. You report what you know, you report right away. And when you report, write down in your chart who you're speaking to, what number did you call, time of day is helpful, and who did you speak to? Sometimes they'll just give you a first name. That's fine. Because if you don't write that down, it's almost impossible to get proof that you made a report. They will not confirm that typically. And so trying to prove that later, if you don't have a chart note, besides, reporting abuse is a really important thing. Important things go in the chart. So you have immunity for good faith reporting. So if you're in there and you can articulate 3 or 4 things as to why you're concerned about this child, you're probably 100% safe. If DHS or law enforcement comes looking for the file on the child, not anybody else, on the victim child, they can access it by statute 419B.050. They can do that, and it's mandatory. You must give them that information. Making a report, do it immediately, but you can consult with people. I get people consulting all the time, and it's been a few days or even a week. You want to do it relatively quickly. It says immediately, but you should consult. We've had people report things that they probably shouldn't have been reported or wasn't reportable. So there's a definition for abuse, lots of different definitions. There is that 3-year rule for age of consent for sexual contact. So bottom line, if the perpetrator is less than 3 years difference from the victim, then that is a defense to these criminal statutes involving minors. And it is not considered abuse if there is less than 3 years difference, as long as they're both 15 or older. Once you get under the age of 15, you cannot consent, period, to sexual contact. It is reportable 100% of the time. When they're 15, you look at the ages and you look and see whether there's coercion, various other things. But bottom line, if it's consensual, it's not reportable as long as they're both 15. That alone took me about a week of going through those statutes. So I have one sentence in my seminar that took me a week to put together because the way the statute is written, it applies to some of the abuse reporting and some of the others and not. And so elder abuse is the similar type of thing. Exact same 3 things come in. The definitions are a little bit different, but bottom line is you're required to report if the 3 things come together. You're on the list. You have reasonable cause to believe abuse has occurred. The person is over 65 and you've had contact with the elder or the abuser. That's often something that's missing in child abuse. So if you have not met the child and the parent is coming in telling you all these tales of woe of what might be going on at the other parent's house, you are not a mandated reporter under the circumstances. You have not met the child, period. Now, if you've met the child in the waiting area, I think that's enough. They don't have to disclose the abuse to you. That's not meeting the child. There's just a physical contact that you have to have with this particular reporting statute. Same with elder abuse. You have to have met the abuser or the elder. Same exceptions for psychiatrists, psychologists, clergies, and attorney. You have immunity. Abuse is defined. They have more financial stuff in there, abandonment, neglect, things that you would normally associate with elder neglect, abuse, those types of things. Willful energy. They actually have verbal abuse as well, swearing at them, threatening them. I'm just going to go through these really quickly. All of these have the exact same things in terms of you got to be on the list. You have reasonable cause to believe contact with the person. Could have made my slides a little differently. In this, more sexual abuse is kind of the primary one, financial and sexual abuse. Spousal abuse, there is no mandatory reporting for spousal abuse unless one of them is over the age of 65 or one of them is under the age of 18. Be interesting because they're considered an adult if they're married, and so is that really child abuse? Be an interesting question. Squeal on your colleagues. You have to report other healthcare providers, and if there's 20 some boards, so chiropractors and massage therapists and other therapists and MDs and all that sort of stuff. This does not require confidentiality. I mean, this does not require meeting that person. So there's no meeting the person requirement. And this one does not override confidentiality. So abuse reporting typically is whether the client wants you to report or not, you're reporting, you're mandated. That's what that means. And so it overrides confidentiality. Here, I was the one that put in language that said unless state or federal confidentiality laws prohibit disclosure, then you're supposed to report. So here, if you learn from your client that another therapist is doing bad things, you can't report. And so if you learn about it outside the session, then you're a mandated reporter. So if you're at a party and you see one of the other therapists behaving, sexually harassing somebody or whatever, it could be a reportable event and you can talk to them. And sometimes you can get them into treatment or whatever they need to have take place. But bottom line is, you're going to be on the path to reporting. And I would let them know, hey, I am obligated to report. And, that's the way things go. They can then get treatment and then use that as part of their self-disclosure to the board. And basically anybody who is violating the ethics of their profession, of these 23 boards, if they're licensed, certified, or registered with the board, and it's Oregon boards only, then if they're doing things that are contrary to their ethics, then you are mandated to report. So here's all the boards. The cemetery board, I mean, why are they on there? Are you abusing? I don't know. Maybe, I guess you can do those things. So these we're not going to go over for right now. Let's open it up to questions and talk as long as we need.
Before I do the questions, in case anyone needs to hop off, I want to let you know that the CE verification code in honor of my favorite holiday, that's 1 week away, is WITCH, WITCH. So again, you will receive a survey shortly after this webinar, and please enter this code in order to get your CE certification.
And you just sat through 4 hours of an attorney talking at you. You deserve rewards. So after this, go reward yourself with something nice.
Yes, definitely. So I'll run through as many questions as we can get through. The first one is, it is my understanding that we are responsible for EHR records, even if they have data loss. Given this, how often should we create a personal backup of EHR, if ever?
You should always have a backup. And so know what that process. So typically you would export stuff to a file. That's usually what it is, but some of them have made it even easier. But what format is that in, and do you still need that program to view it? If it comes as a PDF file, then great, you can see everything in the PDF file. Or does it come as a particular type of file that only that program can see? And if you're going to stop using that program, are you screwed? And so know that before you go in and buy the EHR, how do I get out of it? How do I make sure I have all my data? And I would periodically, make sure I have some sort of a backup. Trying to think of the name of the group that went out of, was it Care Paths that had a data loss of some sort? Yeah. And so I wasn't involved in that, and so I don't know the outcome of it, but that's always a concern. And I would kind of just trust your gut or trust your IT person saying, hey, one, how difficult is it to do this? And how much storage space does it take up on my system? And what's it cost me to do a data dump once a month or something like that, because losing 1 month of client files is one thing, but losing 4 years or 7 years or whatever it is really a problem.
Awesome. Next question. Professional will. I have not been able to find a custodian of records. How do we comply with this requirement?
You got to find somebody. So you get on the listserv, you start knocking on doors, you figure out, hey, I'll be yours, you be mine. You just got to go out and actually talk to people and say, hey, what can we do here? Because you got to get somebody. And that means you got to convince somebody to be able to, and you got to talk to them about, hey, it's not a huge deal, um, but somebody should be familiar with your type of client, I think, is a starting point, not just some forensic psychologist who's never done play therapy or, whatever it is. I think you'd start in the clicks that you're in and talk to people, but using the listservs is a great way to do it. But I know people every year I get reached out by people saying, hey, I can't comply with this. What do I do? Um, and we've tried to get the association to do some stuff and they've done some, but it's kind of a hard thing to put together, frankly. And a lot of people don't want to do it, but they realize they got to have one. So I think everybody should really say, hey, today is the day I'm not going to say no to being somebody else's custodian. Get a document together, tells what you're going to do, whether you're going to be paid for any of your time or, and passwords and various things, how to get the locks. So there should be some things. Um, but yeah, you got to have that or they'll eventually sanction you.
Quick follow-up on that. Someone asked if the custodial needs to be a psychologist or can it be a master's level therapist?
I'm trying to remember psychologist. I believe it needs to be a licensed psychologist in Oregon. The others have broader definitions, and I don't remember them off the top of my head.
We had quite a few questions come in regarding practicing therapy if the therapist is out of state or out of the country, or if a client is simply on vacation. So just some clarity on that.
Um, you can be anywhere on the planet and see Oregon-based clients or clients based where you're licensed or able to see clients, like in California for psychologists. Otherwise, you got to be licensed in that state where the client is physically present at the time. And so that's what determines jurisdiction. Where are they physically located on the planet? Can I practice there? If they have licensing laws, then you got to follow their licensing laws. Some countries don't have licensing laws. And so if they're in Congo or Nairobi or wherever, there may not be laws that govern counseling, psychology, social work, you name it. And so bottom line is you got to find that out. And it's difficult because oftentimes their statutes are not in a language that you can read. And so it's difficult for me too. But bottom line is, can I practice where the client physically located? You can be anywhere, you can be vacationing, you can travel the world and see clients and get paid. Perfectly okay.
Well, we are slightly over time. Would you like to still do some more questions or?
If people are interested in me answering questions, I'm happy to answer them.
All right. Well, with 200 people still online, I'll take it that they'll still listen.
Yes, there's an interest.
I'll do at least one more. We'll see how everyone's
All right.
feeling.
Yeah.
Regarding abandonment, What about a client who hasn't responded to me or reached out for services in over 30 days? If I send a letter letting them know the day in which their chart would be closed, say a week from the date of the letter, without a conversation with them, would that be considered abandonment?
I would probably give them another 30 days, just because that seems to be the most common time frame that is reasonable to transition people. And so bottom line is I would send them the letter. I would also have had something in my informed consent that says, hey, if I don't see you in 30 or 60 or 90 days, I'm going to close your file. And so that can happen automatically, but I would still want to send a letter if I'm closing somebody's file because of that. It just gives them an opportunity to maybe reach out or maybe tell you, hey, this is why I'm not talking to you anymore. I'm mad at you, or, other things have happened. I'm feeling better. I don't need you, you know. But I would want to communicate that, and I would want to at least be available for 30 days. And that's not a law, that's just Cooney's view of the world. So
We'll take it. All right, I'm still seeing people, so I'll do one more. What
yeah.
is, oh wait, let me see. There we go. Someone asked, since you are licensed in Washington, is there anything that stands out to you that is different or should be known for those dual licensed in Oregon and Washington?
Yeah, there are lots of things that are different. I just don't practice up there enough to be the one to give you advice. Dave Madigan in our office does far more Washington cases. He represents a number of groups up there. And so he would be the one to talk to. Um, at one point in my career, I knew all the Washington stuff, but I just haven't been taking cases up there. And so I don't know. And a lawyer said, I don't know. Oh my God. We're supposed to know everything.
I do have plenty more questions, so up to everybody.
Yeah, let's do a few more.
Okay. For reporting child abuse, do you also have to have contact with the child who has allegedly been abused?
Say that again.
It sounds like for a child abuse report, do you have to have had contact with the child who has allegedly been abused?
Yes, contact is a requirement. If you do not have contact, you are not a mandated reporter, period. You can have all the suspicions and video evidence and all that sort of stuff. But bottom line, you would not be mandated to make that report. You could make a permissive report. But bottom line is typically you'd want to talk to the client. If you're not mandated, what is allowing you to breach their confidentiality to make the report? And so if it's not mandated, I would probably want to get client consent to do that. But yes, you have to have contact with the child. Otherwise, it is not mandated. You just have a problem on your hands and you got to try to figure out. But there is nothing saying override confidentiality, make a report, tell this agency everything about this kid and this family. Um, so, yeah, contact is key.
Okay. And then someone asked, when a therapist goes on vacation, do they legally need a therapist to provide coverage for them if they will not be available?
Depending on your clients, maybe. General practice, no, probably not. But if you have somebody that you're specific and concerned about in the last week or two, they've really kind of decompensated or really concerning you, I would probably want a live person to be able to take that person's call. And so I might just make a special arrangement with a colleague saying, hey, if Betty Sue calls and here's her history, and allow that person to make that call. Um, You're not required to have it, but I think it's a good idea for at least the more extreme clients to have some level of cover. Especially if you're the person who's going to, a 8-day rafting trip where there's no self coverage and all that sort of stuff. I mean, you've got to have some services for your client. Hopefully you've got a written safety plan in the chart. Too often people go over safety plans and they do not write them down and do not give a copy to the client. I know a therapist who has little pre-printed cards that are laminated, so about the size of a credit card, and they go in your wallet. I think that's a great resource for clients. They can't say they didn't know what to do. And so that's why I think it's important to have those written safety plans in place.
Another couple questions is, can non-custodial parents give consent, and at what age can a child refuse visitation with a non-custodial parent?
Um, Age of consent is 14 for mental health services. In terms of when the child can refuse to do visitation, that's a family law question, and there is no specific age, but they will sometimes take input from the child or children, but um, I don't know specifically that there's any age for that. I mean, age 10, they can be at home for periods of time and not have people, not have adults around, and there's ages like that, but there is no set age that says, hey, at 15, they could decide who they want to live with.
And then can you elaborate on what contact with the child or abuser means?
Minimal contact, I think, is sufficient. So if you go out into the waiting room and the child is sitting out there with, another adult, and chat for a second, I think that's contact. Or if the client brings a child in to play in the corner quietly while you're having a session, that's contact. Um, but if you've never met the child, never talked to the child, never seen the child, that's not contact. And so that's really kind of where I would take any minimal type of involvement with the kid. Um, just seeing them, I think, is probably sufficient. It's not defined, and we don't have cases that define that any further.
And a couple questions come in the chat right now. If you go on medical leave, um, example, maternity leave for 3 months, do you have to terminate all clients?
No, you can give the clients the option. Do you want to pause treatment? You're in a good place right now. Is it a good time to pause and see how you do in the next 3 months? Or do we want to have a backup, therapist? So you need a referral now. Or do you want to go see somebody while I'm on maternity leave and um, you can make a decision whether you want to come back or not. But you do not need to terminate them. You can give the client the option.
How do you recommend we make sure our custodian of record can access our client files in the event something happens without violating HIPAA?
Yeah, that's a kind of a hard time away sometimes, but typically you can give them an office key, and they would just use that when something has happened, or somebody would have an office key. Um, you got to kind of think through all the possible ways to die or to become incapacitated. So it's a little morbid, but bottom line, if you give it to your spouse thinking they're going to be surviving you and you both go down in a plane, now somebody can't get into your office. But you should make arrangements so they at least have a key to something, and then there would be another way to get into other things, like a lockbox. So there's a safe with a note to the custodian records. Here's all my passwords. Here's where I store my data. Here's how I do things. I think having some conversation about that is a good idea. Um, OPA used to have some good professional will information on their website, and I'm not sure if they still have it. I'll have to check, but that was very helpful. Or you can go to somebody who does professional wills, and they often have good ideas about how you do that super secret handoff kind of stuff. But they will need all your passwords to access your system. They will need things to be unlocked and that kind of stuff. So they need keys and passwords at least.
Is a child being in home during verbal spousal abuse mandated for reporting, with further caveat that you had brief contact with the child in the waiting room?
So contacts, you're on the list. And the question is then, do you have reasonable cause to believe that abuse has occurred? Verbal abuse is typically not abuse, as in domestic violence kinds of things. Shouting is not typically considered um, something that you can arrest somebody for. It's when it gets physical. When it gets physical in front of the kids or the kids are at home, that is considered a mandatory report because they were subjected to that. You know, sometimes there's questions, well, they were at the far end of the house and they were sleeping and there was noise generation machines on, and bottom line is, if you think you need to report, you should report. I'm not a fan of some of the requirements to report. I don't think that's always in the best interest of the clients, but unless you're a psychologist or a psychiatrist, you're generally mandatory reporting things like that. I
And
wouldn't
so,
parse it too closely.
someone asked to clarify if spousal abuse is always a mandatory report or just when it's in front of minors.
Just when it's in front of minors, it should be a mandated reporting thing, in my belief, because it's underreported in many cases. But bottom line is, it is currently not unless children are present at the house.
Um, our agency employs peer support specialists to help bridge the gap between clinical therapists and community-based support. Since we primarily serve youth, peer support specialists often transport clients to activities outside of the home or office settings. Are there any age-related restrictions in Oregon that would prevent a peer support specialist from transporting minors?
Well, they need to be 16 to get a license, and so as a lawyer, I hear that and I think, oh my God, we got problems all over the place. It's kind of like a bar review question where it's, how many issues can you spot? Driving people in your car, unless you have an endorsement for business use of your car, means if you get in an accident and it's business related, i.e., taking clients to some peer support meeting, um, you would not have that person driving would not have any coverage for that accident. And so you're potentially putting your clients at risk. There's also been a whole number of cases where the peer support people are doing untoward things with each other. And ultimately, the therapist is the one responsible for that because you introduced them, so to speak. And so if they're having sex when they shouldn't, or they're having all sorts of different things that are going on, or they're selling drugs or sharing drugs, or whole variety of things that have happened in the past, um, I would be very careful with that. I would want to make sure my insurance covered everybody, not just my employees, but these, peer specialists, because there has been a history of problems in that arena.
I had someone ask if you receive texts, emails, videos from a client, are you required to respond and add the information to the client's chart?
If it's from a client, it is part of your chart, period. It has to be part of your chart. And people often overlook that and say, no, I'm not going to do that, or whatever it is, but they don't, or they just store it somewhere else. And then they have to do all this work to get things put together. But emails, I'm not sure why the client is sending you videos. Kind of depends on the video. The bottom line is that becomes part of your chart. And if they want somebody asked for the chart, they would get all of that information if that's included in what they want.
Awesome. I had a scenario presented to you. If you're treating a 16-year-old and suspect that they may have a substance use disorder or disordered eating issue, and they don't want parents to know, these could be safety issues. What's the best advice around this?
I would talk to your client about the fact that the parents do have rights to access the records under certain circumstances, and that I would encourage them to have a conversation with their parents about it. But some parents are not parents of the year, and that can be dangerous. And so, understanding that, I wouldn't say, hey, I can keep this entirely from your parents, because you can never promise that. They could subpoena it, they could do a variety of things to get that access. And so I would talk to the client about that, saying, hey, it's not a given that this is going to remain secret forever. So do we want to develop a plan where we would inform your parents of some of this information and get them on board? And do you want me to do that, or how you want to do those types of things? But you got to make your treatment recommendations, and those are going to be in the chart. And so bottom line is, parents may be able to get access to that chart And it would be interesting, depending on the reasoning given by the 16-year-old, could the clinician say, I agree, this is not in the best interest of the child to send this information to the parents? Substance abuse, I think a parent would want to know. Same with eating disorders. But again, depending on the family dynamics, you have to make that call. That's why you get the big bucks as the high paid therapist that you are to make all these decisions.
Um, Kaiser is now requiring their contracted providers to enroll as Medicare providers. One, is that legal? And two, are there any concerns about this person re-enrolling in Medicare after 20 years or so of not being a Medicare provider?
I would guess it's legal. I am not going to give you a definitive legal opinion because it depends on a lot of different things. But bottom line is, if they have panels that they want people on, they can make that as a requirement to be on their particular panel. And so I think that would be a voluntary business decision that you would make. You know, it's coercive, but I don't think it rises to the level of, you know, um, threatening somebody, you know, with harm or something like that, making them sign something against their will. And what was the second part of the question?
If there's any concerns about re-enrolling in Medicare after 20 years or so of not being a Medicare provider.
Well, there's a reason to be concerned about Medicare, regardless of whether you've been there 20 years, you know, haven't been there in 20 years or have been for the last 20 years. It is a complex system. The billing rules are complex and obtuse is the word I'm looking for. They are terrible. This is why I stay out of advising on Medicare and Medicaid typically, unless know for a fact, hey, you can do this certain thing. Um, yeah, I think going into Medicare, I would probably want a refresher course. Billing Medicare, Barbara Griswold would be a good resource for some of that information. Consult with people. But the policies have changed in the last 20 years for sure. And so going back into it blind would be quite daunting. And so I would probably want to get some resources together.
Can my client's partner, haven't seen the partner, subpoena my client's records in a custody case?
Yes. Records can be subpoenaed by anybody involved in a lawsuit as long as they're relevant to the lawsuit. Good attorneys can ask for protective orders and say, hey, only certain people can see this stuff, or hey, there's no reason at all for anybody to get into the records because we're a no fault state, or, you know, there's a lot of different things they can do. But yes, your client's records can be subpoenaed if they find themselves in any type of litigation, criminal, civil, you name it.
Are we able to make cash pay agreements when OHP members want to see us, but we are not in network?
Yes. So number of months or maybe about a month ago, I posted on there that you can, in fact, direct bill your OHP clients. You have to give them some information. You have to tell them, hey, OHP, this is a covered service. OHP would pay for it, and you would not pay anything out of pocket. Um, you're doing this voluntarily. And there was something else. And the clinician cannot charge anything more than what OHP would have paid. If you do all that in writing, keep a copy in the file, give a copy to the client, then you can bill directly. Used to be illegal. Um, but if they don't tell you, there's an exception for that. There's also an exception if the client just doesn't want to use their OHP, they can use that. They can do that.
It looks like one more question here in the chat of those who've stuck around is, can you talk about in-network insurance plans dropping reimbursement without cause or notice, even when there is a contract? Kaiser and PackSource were examples given.
Typically, they would be required to give you notice to change those. And so you would have to have your original contract that you signed with them and see whether or not it's been renewed. and whether any contract changes have come, because oftentimes they don't send it directly to you, they post it on their website. And if you're not searching their website for all their new updates, then you may not know about language changes in things. And so, bottom line is, yeah, you can kind of get behind things and suddenly realize, hey, they've changed things. But typically, in order to change the rates, they have to give notice. Typically, it's at least 45 days. More often, it's 60. But yeah, in order to change terms of the contract, they have to maintain the contract as is unless they give proper notice. And just because you didn't receive it doesn't mean they didn't give proper notice as defined in their contract. So the contract will tell you how notice is given, how much notice needs to be given, and how certain things happen. So any contract you sign, this is true across the board in every aspect of your life. Save a copy of that contract, period. If you're applying for licensure or renewing, take screenshots if you have to, but have a way to save what you filled out. It's important. You will never usually need your, health plan contract, enrollment contract, but there are times when you need it. If I want to terminate, how much notice do I give them? Where do I send my termination notice? Are there grounds that I need to give for termination, or is this a at will, I can terminate with 60 days notice? Typically, it's at will. They can terminate you with 60-day notice, and you can terminate them with 60-day notice. Typically, what they do is say, hey, we're going to make these changes. They're going to be effective in 45 days. And if you don't like them, you can say no, and we will drop you from the panel. Not very fair.
Well, thank you so much, Paul. I know there was a lot of questions that weren't answered, but I think I've gotten all of the ones for those of you that stuck around here. So thank you for.
Anybody with lingering questions want to email me, that's perfectly fine. And I'm happy to answer them. There's no charge for that. And thank you everybody for showing up today. It feels like Thanksgiving and all the weird cousins come home and all that sort of stuff. And so it's really good seeing people, even if it's just on the screen. So thank you.